The appeals are dismissed.
Obliged.
We're giving them time to surrender to 3rd October. The appeal is to surrender by 30th September.
Appeal of the year 2014, there are certain delay, my lord, delay of 689 days.
It's a delay of 689 days, which is not properly explained. Accordingly, the delay application is dismissed. None appears dismissed.
Infructuous. It is
Infructuous. All right, disposed of.
But at 6, there is no
No instructions dismissed.
May I please your lordship? Item 7 is no instruction, my lord.
No instructions dismissed. Right.
May I please your lordship?
Yes.
This appeal is against the order of the Honorable Single Judge, whereby the order of the collector allowing the appeal of the respondent, thereby disengaging me from the post of Anganwadi worker is under challenge, my lord. Now, initially, this appellant, if your lordship, was engaged as an Anganwadi worker in the year 2007. In the month of June 2008, he took leave for 2 months, maternity leave. Thereafter, he again rejoined. However, the inhabitants of the locality created problem. Instead of solving that issue, the authorities sought show-cause notice on me as to why I should not be disengaged. I moved this noble court in a writ petition, that is WPC number 9895 of 2010, and I was protected. In the meanwhile, the respondent, the contesting respondent who wanted my job, that is respondent number 5, he filed a writ petition for this noble court challenging my selection as Anganwadi worker. Now, that writ petition was disposed of on the basis of submission on the part of the counsel for the state that he should move the collector Cuttack for in appeal, because the guidelines of the Anganwadi worker provides a provision of appeal. Now, my lord, while doing so, the state also justified my selection so far as the post is concerned. Now, my lord, the other writ petition that was filed by me was also disposed of because of the disposal of the writ petition that was filed by the respondent number 5. Now, the matter, the collector Cuttack took up the matter. Your lordship, under Annex 6 at page 20, the collector relies upon a report of the sub-collector by calling for a report. This is a fresh inquiry report by the sub-collector Cuttack, that is Subpara 3. Your lordship will see. Now, on the basis of this, he says, I do not belong to the Anganwadi center area, and that is how I have been disengaged. Now, I moved this honorable court before the Honorable Single Judge challenging same on the ground that as per the provisions of the guidelines, the ATM is the competent authority and not the collector. So therefore, the collector could not have been vested with jurisdiction either by the submission of the counsel for the state or by the direction. And therefore, the order is without jurisdiction. even assuming the collector can decide this has been passed in violation of natural justice, because if the report of the sub-collector has formed the basis of disengaging me, the report should have been provided to me in order to enable me to file objection to that report. Now, my lord, that your lordship will kindly see, the Honorable Single Judge has been pleased to reject my contention by taking note of the report of the sub-collector at internal page 3 of the order, last subpara.
No, you are not being a resident of the Vidyadharpur Nuasahi service area.
Your lordship will kindly consider, they selected me saying that I am the resident of the area. In the writ petition that was filed before this noble court by the respondent number 5 on the earlier occasion, the state government also justified my selection by saying that I belong to that area. Now, after remand, the collector exercising the appellate power, though the collector is not vested with the appellate power, the ADM is the appellate authority as per the executive instruction. The instruction provides specifically ADM is the authority. The collector could not have exercised the power. Collector could have simply said, no, it should go to ADM. But the collector has exercised, be that as it may. Now, the collector calls for a fresh report. This sub-collector report, which the collector at page 20, your lordship will see, has relied upon, has formed the basis of my disengagement. And now this sub-collector report has not been provided to me.
No, whether whether you're residing in that area or not. It's nothing to do with getting copy of the report and all.
But that is my consistent claim that I am residing in that area. And that is what has been supported by
Have you supplied any proof of your being a resident of that area?
The documents pertaining to me residing there, the residential certificate, everything was filed. So therefore, I have formulated 3 points at paragraph 2 of this appeal memo for your lordship's kind consideration, my lord. Your lordship will see. I had filed because on the basis of that, it was scrutinized, I was selected. And even in the earlier writ petition that was filed by the respondent number 5 before this noble court challenging my selection, the state government justified my selection, saying that I belong to the area. So now after remand, a fresh report is called for, and that fresh report has formed the basis. It is not on the basis of existing material.
No, what is the document to show you are a resident of that area? You show us.
That your your lordship may pardon me, so far this writ appeal is concerned, I have not annexed, but that was your lordship part of the writ petition. Your lordship will kindly see. That is page 22 to 32 of the writ petition, your lordship.
Yes.
Now this is Vidyadharpur. Your lordship will see the nativity certificate, page 22 of the writ petition, your lordship.
No, you're a resident at the time of applying for the job. That's the main thing.
Yes,
not
my lord.
When you pass the exam or something.
No, this is of 2007. My selection was in 2007, your lordship. They will not accept a resident certificate unless it is within 6 months of preceding the date of selection. And this is, my lord, your lordship will see Vidyadharpur, page 22. Then the next page.
Anyway, you've been out of job now for more than 8 years now.
My lord, by virtue of the order of the appellate authority. I was there. I was discharging my duty. The respondent number 5 set up the village just post my continuance. I moved.
No, but by now there must have been a fresh advertisement. Somebody must be occupying that place now.
The respondent number 5 has taken my place by virtue of the challenge. Respondent number 5, your lordship.
Now she's 48 years.
Now 48.
And I am with the job. My job has been taken away for no apparent reason, though there are telltale documents, your lordship. The IT department, my lord, the PAN card, the election voter ID card, the nativity certificate, everything, your lordship will see, the bank passbook, everything, my lord. And a report which has formed the basis of my disengagement was supplied to me.
Anyway, all right, notice. Mr. Kunti accepts notice for opposite parties. 1 to 4, notice will now issue to opposite party number 5 by registered speed post return appeal. 7 December. All right.
Obliged.
Supplementary list item number 9.
Your Lordship, we are for opposite party number 2. This item has become infructuous. On behalf of Ms. Pamirat, our appearance might be noted.
All right. Counsel for opposite party number 2 states that the appeal has become infructuous. None appears for the appellant. This is for not prosecution.
Obliged, my lord.
Supplementary list item number 10.
List.
The state filed the appeal of the year 2061.
There's not even an application for delay, sir.
My lord. Well, there is a delay of 185 days.
Yeah. Delay of 185 days is not explained properly. There's not even an application for condemnation of delay. Consequently, the appeal is dismissed. Right.
Item number 11.
Item 11, Lordship, kindly pass over.
All right.
Item number 12.
None appears dismissed in opposition.
Item number 14.
None appears dismissed.
Infructuous.
Infructuous. 14 dismissed as infructuous.
Item number 15.
None appears dismissed in opposition.
Supplementary item 16.
Lordship, item 16 and 17 both are infructuous. Lordship.
Infructuous dismissed. All right.
Item number 18.
Delay.
There is a delay, my lord, in the during pendency of this read appeal, my lord, government has considered their case. And in
264 days, sir. Delay of 264 days is not properly explained.
and in compliance to the direction of honorable single judge, we have complied that order.
All right. It is further stated that the judgment of the single judge has also been complied with. Accordingly, the appeal is dismissed.
Item number 19.
None appears dismissed in opposition. Same. 19 both matters.
Item number 20.
May I kindly be granted a 1 week time, my lord?
For what, sir?
Because I have not traced out my file, my lord.
It's all right, sir. Then we'll permit you to revive it. All right. Dismissed with permission to revive it in case the file is traced. Yes.
Sorry, my lord, I may be granted a 1 week time.
No. We'll dismiss it. You revive it, sir. File an application, we'll revive it. Yes.
Obliged.
Supplementary list item number 23.
Order of the learned single judge is a challenge before your lordship. A boy of 8 years fell into the manhole. The mother filed a petition seeking compensation. Your lordship may see paragraph 4 of the judgment of the learned single judge, madam. Paragraph 4, running page 15, internal page 3.
Yes.
There is no dispute as regard to the death of the minor child of the petitioner. There is also no dispute that the death of the minor child is on account of drowning in a place under the custody. NALCO authority also cannot shift their responsibility on the plea that the responsibility of maintenance of the water system as well as sewage system was lying with the contractor. In any case, there was no impediment on NALCO to make payment of appropriate compensation to the bereaved family, which may not be on the head of compensation, but by way of ex gratia, and by holding an inquiry, NALCO could have fixed responsibility on the contractor and recovered the amount from the contractor thereafter. As appears from the case record, the incident had taken place on 14/6/2008, and this writ petition is taken off hearing at the end of 2014. Even assuming that the strong material directly holding the NALCO negligent of the incident, the petitioner cannot be asked now to file a civil suit, as the same will be grossly barred by time. Under the above circumstances,
Nothing,
considering that
these are not matters we should interfere, sir. Some young boy has died, it's all right. By the impugned order, the learned single judge is awarded compensation of rupees 3,50,000 to the family of a child who died by falling into a manhole, which was in the premises of NALCO, the appellant. Full stop. Paragraph. Having heard learned counsel for the appellant and having examined the impugned order of the single judge, the court is not persuaded that the impugned order calls for an interference. The appeal is accordingly dismissed.
The entire quantum has been deposited before this honorable court, my lord.
The amount deposited in this court be released to the respondent upon proper identification and intimation be, nobody is representing the respondent.
In the writ, before the learned honorable single judge, someone was appearing, my lord.
Information in that regard be sent to the counsel who was appearing for the respondent before the learned single judge. The amount together with the interest accrued thereon be released to the respondent forthwith. All right.
Supplementary list item 24.
Item 24, the appellant who was promoted in the year 1992 was continuing against the post of lecturer till his retirement in April 2022. Of course, the interim order was by this honorable court in the division bench on 27/3/2015. And in the meantime, the respondent number 1, who was the petitioner before the honorable court, he has also retired. He has also resigned. Resigned in way back in 2013. I've given a date chart to us.
No. So what do you want?
But now the matter can be disputed because I have already retired in the meantime. The judgment passed by the honorable single judge, I have challenged that judgment. I have challenged on the ground. If Lordship look to the date chart, you also see that.
No. So notice has gone in this already?
Notice has gone. Notice has gone. Nobody has appeared for the respondent because he has resigned in the meantime in 2013. He's not interested because he had challenged my promotion way back in 1992 by way of representation, which was rejected by the Valmi, and he challenged before the this honorable court, and because his representation was rejected by Valmi, now the honorable single judge has allowed.
Who's appearing for this Valmi? They'll still want to contest the matter, sir.
Mr. SK was appearing initially, but not, he has filed also a counter. They're supporting my case. They're supporting my case.
Where is that?
Then before the honorable single judge. Yes, you'll also look to the honorable single judge order, also impugned order. The Valmi stand has also been noted. That is at page 4. Page 5, sir. Page 5. See, SK Nayak and senior counsel for the OP number 2 and 3 stated that is at running page 29 of the writ appeal. Internal page of the impugned judgment at page 5. Say SK Nayak and senior counsel for the opposite part number 2 and 3 stated that the promotion of the OP number 4, I have the OP number 4, to the post of lecturer in engineering faculty was made on 27/2/1992 by Annexure 2, but the petitioner filed the writ application in the year 1994. Therefore, it is hit by doctrine of delay and laches. It is further urged that a vacancy in the post of lecturer occurred due to the promotion of one C. R.C. Naik, lecturer engineering, to the post of reader in engineering, and the OP number 4 was taking classes and gained the experience, and thereafter he was promoted to the said post, but he was permitted to draw the scale of pay of assistant research officer until the revision of pay scale of lecturer was made. He further submitted that the promotion of the OP number 4 was considered taking into account his satisfactory performance and also the fact that he possessed the background of management degree was a great advantage to Almi. It is further stated that as per the government resolution annexure 3, order was issued to keep the petitioner out of zone of consideration for the post of lecturer, the present respondent 1. The OP number 4, having got requisite qualification at the relevant point of time, was given promotion to the said post. Therefore, no infirmity can be found as against the OP number 4 while granting the promotion to the post of lecturer, and the court should not interfere with the same. Now, the honorable single judge, what it has been done, it will also be looked to the paragraph 9. In fact, while my promotion was given way back in 1991, the rule which was governing field, that has not been referred to. A subsequent resolution where the qualification has been revised, that has been applied.
All right. See, this present appeal is directed against the judgment dated in December 2014, passed by the learned single judge, holding the promotion of the present appellant as lecturer in the Water and Land Management Institute, Orissa, to be illegal and quashing it, and accordingly quashing it. Full stop. While issuing notice in the present appeal on 27 March 2015, this court directed status quo to be maintained. Paragraph: during the pendency of the present appeal, the appellant has already superannuated.
So in the month of April 2020.
The other important fact is that opposite party number, respondent number 5, who was the writ petitioner.
Respondent 1, sir.
Respondent 1, sorry. Respondent 1, who was a writ petitioner and challenged the promotion of the present appellant, has since resigned from
Yes,
the
I'm giving the
institute
affidavit also. 2013.
in 2013 itself. Full stop. Consequently, respondent number 1 is no longer interested in pursuing the present matter, as is evident from the fact that despite service of notice on him, he has not even appeared. Paragraph. With the above development, the actual challenge to the promotion of the appellant by respondent 1 has become academic, and therefore the impugned order, the learned single judge, is hereby set aside, and the writ appeal is allowed, but in the circumstances with no orders to pass.
So for the pension and other benefit, you're also making.
Yeah, all retirement benefits due to the appellant be reworked on the basis of the present judgment and be released to him at the earliest, in any event not later than 8 weeks from today.
Fine. Obliged.
Taken on record. That's it.
Supplementary list item number 25.
None appears dismissed in opposition.
Supplementary list item 26.
Item 26, my lord, no instruction.
No instructions dismissed.
Item number 27.
None appears dismissed in opposition.
Item number 28.
28, my lord, no instruction.
No instructions dismissed.
Item number 29.
None appears dismissed in opposition.
Supplementary list item 30.
I am appearing for the opposite part number 5, man.
All right. None appears for the appellant dismissed in opposition.
Supplementary list item 31.
None appears dismissed in opposition.
Supplementary list item 32.
32, my lord, may pass over the matter.
All right, pass over.
May I make a submission 32, my lords? I am for MCL. The learned court below had asked for eviction subject to giving them transit quarters and plot to be allotted. May I make a request that 1 week time is given so that I can give a list that all the petitioners have been allotted with the plots in the meantime.
Let's see what happens when it's passed over.
Item 33.
Kindly pass over, my lord.
Pass over.
Item number 34.
My lord, no instruction, my lord. There is
No
no instruction.
instructions. All right, dismissed.
Item number 35.
None appears dismissed in opposition.
Item number 36.
None appears dismissed in opposition.
Item number 37.
None appears dismissed in opposition.
Supplementary list item 38.
None appears dismissed in opposition.
Supplementary list 39.
None appears dismissed in opposition.
Item number 40. Item number 41.
My lord, the file is misplaced, your lordships. Your lordship,
Dismissed with liberty to revive it in case the file is located.
my obliged.
Item number 42.
None appears.
I am for the appellant, my lord. My lord, the petitioners have limited prayer in this appeal. Already the direction given by the Honorable Single Judge has been complied with as per direction of my lords dated 23 to 15. My lord, the limited prayer of the while passing the impugned judgment, the Honorable Court, Honorable Single Judge held in first paragraph of my lord, page number 19. Reading the clause 5.3 of the aforesaid decision of the ESI Corporation indicates that all the medical treatment benefits cannot be extended to the persons born before IP into this ceiling mentioned earlier. In the case, the child born after IP had become eligible for super specialty treatment. It makes clear that the person suffering congenital disease can be covered up to the ceiling mentioned earlier only in the case child born after the IP had become eligible for super specialty treatment. Section 56 of the ESI Act nowhere puts such a restriction. It is made clear in Section 56 that the insured person and his family members shall be entitled to receive all medical benefits. The restriction in clause 5(3) in the decision of the medical service July 14 runs contrary to the provisions contained under Section 56 of the ESI Act. Above the restriction is adheres the statutory provisions and cannot be sustained in the eye of law. My Lord, while passing this judgment, Honorable Single Judge did not consider Section 57 and Regulation 95(a) of the.
What is the relief granted?
My Lord,
What is the relief granted?
My Lord, the daughter of the insured person was suffering from
Sir, did you understand the question? Twice it is asked to you. Have you understood the question?
Sorry, my Lord.
Third time I'm asking you, what is the relief granted to the writ petitioner?
Super specialty treatment at Hyderabad.
What is wrong? What is wrong with that order? And have you complied with it?
We have complied with
then why are you still challenging it? The treatment is all given and over.
My Lord.
Then what are you asking us to do now?
My Lord, I am asking that the Honorable Single Judge held that.
So today we set aside the single judge's order.
My Lord.
You can reverse the treatment.
No. We have already extended the.
What is the purpose of this appeal, sir?
My Lord may say that.
By the impugned order, the learned single judge had directed treatment to be afforded to the respondent in a special super specialty hospital in Hyderabad. According to the appellant, that treatment has already been provided to the respondent. In that view of the matter, with the impugned order of the learned single judge having worked itself out, the court sees no purpose in entertaining the present appeal, which is accordingly dismissed.
Supplementary statement.
43 and 44, but the suit out of which this appeal arises has already been disposed of. So therefore,
all right. Counsel for the appellant states that the appeal has been rendered infructuous. These are disposed of as such. All right.
Item 45.
44 also same.
Yeah, 44 same order. 45.
45.
May please, Lordship. In fact, Lordship, with great respect, Lordship, I want to make a submission. At around 10 o'clock, I got the list, Lordship. The contesting matter, Lordship, permit one day, any day, Lordship, I can.
No, we'll just read it right now, sir.
There are two writ appeals, Lordship.
Petitioner is not a resident of Adal 2.
In fact, no, Lordship. I was selected, duly selected, considering my resident there in Lordship. But subsequently, they are taking a plea that subsequently my residence certificate has been cancelled.
Yes.
That is under challenge also in the writ appeal, one writ appeal. And in other writ appeal, Lordship, we are challenging, Lordship, the order of the appellate authority, Lordship. And Lordship, kindly see here, Lordship, I am continuing since 13 till date, Lordship, as Anganwadi worker. In the meantime, I have served around 10 years. And Lordship, kindly see the language of the guideline, Lordship. In Lordship, it only gives preference to the women of the locality, Lordship. And in the meantime, Lordship, the opponent who is challenging my order, she has already got married and she is residing elsewhere, Lordship. I am continuing since last 10 years. And Lordship, moreover, another
There's
point.
No interim order in this appeal.
I am continuing, Lordship. Because status quo order there, I am continuing there, Lordship.
Where is that?
Lordship, in both the writ appeals, Lordship.
Status quo is there.
Lordship, that. And pixel, Lordship, one document in my writ appeal I have annexed. I have given 32 documents, Lordship, in support of my residency, Lordship.
Who's appearing for opposite party number 5?
My Lord, by fraudulent manner, he has obtained residence certificate.
No, apparently you have married and left. You're not even working there.
My Lord.
You're not residing there.
My Lord, he obtained a residence certificate. After my complaint, that was cancelled. that the cancellation was made at 21/2/2013. He got appointment 5/7/2013 after cancellation. How he managed there?
No, but what is your position, sir?
My lord,
Is your client still interested, or she is married and gone?
no, my lord, his cancellation, his certificate was cancelled as a
Why don't you answer the question?
My lord,
Are you following the question I'm asking you?
my lord, no, I am not following, my lord.
I'll ask my colleague to ask.
The question was that you got married and went away. You are not staying there. What is your interest?
Yes, my lord. I was married after selection. After 2017, not the date of selection. I was not married.
So today what will happen?
My lord, in fraudulent manner, he has obtained certificate. That was cancelled. And thereafter writ appeal was remanded. And ADM was considered everything. Well, his appointment was cancelled. His relativity certificate was cancelled 21/2/2013. How she got appointment 5/7/2013? After cancellation, he has not obtained any stay order, not challenge here.
So you are not interested for your case. You are interested for the case of the other side.
My lord, lordship, the miss case I have filed vacation of interim order 245. 245 miss case 2015 mile. Lordship got it. The miss case I have filed for vacation of interim order. Lordship got it. Annexure R/2, page 12 mile. Page 12 mile. Page 12, paragraph 5. However, in the present inquiry made after receive the complaint, petition made by Santoshin Kumar Patra, the above noted fact have been narrated. In this connection, further I am to submit that during my inquiry village at Adal, the harvesting season of paddy was in full swing, and there was hardly any appearance in the village due to their engagement in the paddy field. And thus I had taken signature of 2 persons who were present in the village during the inquiry, who impersonate themselves to be Vivekananda Pradhan and Brindavana Karan, and while putting their signature as witnesses who admitted the fact that narrated above and admitted above the parayancy of Surendra Mudli, the present petitioner, the Vaira at as village Adal, relying upon revenue records and basing on the ROR Khata number, plot number, such and such. Adal, which was stand recorded in the name of the Surendra Mudli, along with others of all are the Keuta by caste and village Adal. I was reached to such opinion. During this inquiry, I appears that hatching conspiracy had been made to convince the field inquiry by the appellant, the present appellant. As the Vivekananda Pradhan, who has put his signature as witness personating himself, as such was not in the actual person. That on that basis, the Lordship see the Tahsildar cancellation report, my lord. On that basis, it was cancelled. It is RI report, and how he managed there. Then Lordship see the page 14, my lord. Page 14. Page 14, the second, since the hence the residence certificate bearing number 1842 dated 31/3/2012 is cancelled, and she Muduli is directed to head the certificate to the office. That was a that was an order passed on 21/2/2013.
that was a cancelled residence certificate. Against that, he has not paid appeal till there. And after obtaining appointment on 5/7/2013, he then made an appeal. How he got appointment? How she got appointment 5/7/2000? That is ADM report. Let's see the ADM pass an order. After the appeal, ADM has passed detailed order. That is page 26, my lord. 26. May I read, fine? In proper adjudication of the appeal case, peruse and examine the relevant documents like residence certificate issued by the Tahsildar Biromahadpur, cancellation order, inviting card of marriage of Harendra Muduli, Jagabandhu Beria, village Jubarajpur, voter list notice and mutation case number, Biromahadpur Tahsil, which has been received by the respondent number 3, the present appellant. The ROR of the settlement khata number such and such recorded in the name of the Jagabandhu Bahira, the husband, and the respondent number 3, and the revised guideline of selection of Anganwadi worker. The order of the Honorable High Court of Orissa, WPC number 1620 of 2013, filed by the appellant, order number dated 19/7/2013, as Honorable Court has given effect to affording reasonable opportunity to hearing both the appellant and the respondent. It can be logically established that Harendra Muduli, wife of Jagabandhu Baria, is not a resident of Adal 2 center, and hence she does not belong to the service area of the Anganwadi center, and that the selection and engagement of Harendra Muduli as Anganwadi worker has grossly violation of government guidelines for selection of Anganwadi workers. In all fairness, it will be proper disengage Harendra Muduli forthwith when she does not belong to Anganwadi center area, has a and her application should have been rejected at the preliminary stage. The sub-collector Biromahadpur.
Sir, the order will follow.
My lord.
Order will follow.
Then, Lord, say, my lord, my humble submission, after the cancellation, she cannot be married. But how he managed, appointed, he managed in obtaining certificate, and he managed here to obtain a appointment letter. My humble submission.
The appeals are dismissed.
That is a case, my lord.
Appeals are allowed, sir.
Supplementary list item 46.
Radhesam Sarwar, it cannot be made appeal, appeal. That was a cover judgment. Let's say I will passing over Lordship for that is a cover.
All right.
Supplementary list item 46.
Yes.
All right.
Item 46.
None appears to dismiss in opposition.
Item number 47.
None appears to dismiss in opposition.
Supplementary list item 48.
My lord, item number 48, no cause of action survived.
All right. That stated that the appeal has become infructuous. Disposed of us.
Supplementary item 49.
None appears to dismiss in opposition.
Supplementary list item 50.
Infructuous, my lord.
Infructuous. All right.
Item number 51.
None appears to dismiss.
Lordship, on the appellant court.
Yes.
Challenging the order of Honorable Single Judge dated 23/3/2015,
Yes.
allowing the interim trust board for the puja of the deity Ma
Gopinath Dev, Ma Charchika Thakurani, and Kapileshwar Dutt. In spite challenging not up, the appellant was appointed as the managing trustee by under Annexure 1 Lordship. And they have issued, respondent number 2 issued the Annexure 3 for objection on the interim order of the objection, inviting suggestion and objection, Lordship. In spite of they have filed a writ application before this honorable court, and honorable court was ordered under Annexure 6, page 20 for allowing the interim trust board, Lordship.
What has happened to the main writ petition? Is it a final order or interim order?
Interim order.
So that we say order here, we continue doing the pendency of the writ petition. Is it still pending? Writ petition is still pending or not? Why don't you check on the net? Writ petition number 1340 of 2015.
Yeah. Please.
Oh, a whole writ petition is this year. So it's still pending. See, none is appearing. The challenge in the present writ appeal is to an interim order dated 13/1/2015, passed in writ petition civil 1340 of 2015, while admitting the present appeal on April 2015. Sorry, on 30th March 2015, it was directed the status quo should be maintained with the parties. That status quo orders continued. Paragraph. If there be no contest in the present writ appeal, it is directed the order passed with this court on 30th April 2015 will continue during the pendency of the writ petition. Accordingly, the impugned order of the single judge is hereby set aside. The writ appeal is disposed of in the above terms. Writ petition civil 1340 of 2015 will now be listed before the roster bench of the single judge on 14th November 2022 for being proceeded in accordance with law.
Supplementary list item 52.
May it please, Lordship. Here, I am against the order of the Honorable Single Judge. The two workmen herein were dismissed from service for allegedly found sleeping. And
408 days delay, sir.
There's 1 year's delay.
408 days.
I
the delay of 408 days in filing the present appeal. The delay has not been properly explained, and therefore the court is not inclined to condone the delay. MC number 206 of 2015 is dismissed. Accordingly, the appeal is dismissed. Yes.
Item 53.
Again.
Item number 53, state is the appellant
yes.
against the judgment passed by the Honorable Single Judge, wherein this Honorable Single Judge has held that the writ petitioner is not liable to pay the amount demanded under the OPDR Act towards deficit stamp duty, which is to be paid against registration of a particular cell deed. Your Lordship, the matter is very short. The writ petitioner presented a cell deed for registration, and admittedly that cell deed was impounded on the ground of less of stamp duty. So we initiated a proceeding for recovery of the balance deficit stamp duty. There he took a plea that this cell deed is void. I have not acquired any title on the basis of this cell deed. Therefore, I am not liable to pay the deficit amount because this cell deed itself is void. I cannot claim any right title. That is his representation. So the Honorable Single Judge, on the basis of this claim of the writ petitioner, came to a conclusion that since the petitioner himself is saying that it is a void cell deed and he is not claiming any title over the property on the basis of that cell deed, therefore he is not liable to pay the deficit stamp duty. My only contention in this writ appeal is such a finding of the Honorable Single Judge is erroneous, in as much as, Your Lordship may kindly say, instrument is registered, and now he is himself saying it is a void document. Nobody knows whether he is utilizing that cell deed, whether he is getting benefit under that cell deed or not. But as far as the registration department is concerned, IGR is concerned, sub-register is concerned, they are only to see that the instrument has been registered and there was no cancellation of that registered sale deed. Once it is registered, the stamp duty has to be paid, irrespective of the fact that the sale deed is legal and illegal. Now, one thing your lordship may kindly imagine that this sale deed is a void document and no title has been derived by the writ petitioner. There is no civil court judgment on this aspect. He is saying that it is not property. I have not acquired this property.
What
on
is
the
the
basis
differential
of,
stamp duty?
I will not. So this is not a justifiable ground.
What is the differential stamp duty, sir?
Differential stamp duty. Your lordship may.
If it's not substantial, then we'll leave the question open for some decision some other case.
79,000. 30.
This is not
7, para 7 of the writ appeal.
All right. Then we'll leave the question of law open. You see,
it is
considering that the differential.
My lord, 79 lakhs. I'm sorry. 7 lakhs 93,000. 7 lakhs 93,000.
7 lakhs.
Para 7 of the writ appeal may kindly be seen. Para 7. For 1 second, your lordship may kindly have a glance. Para 7. Directing her to deposit 7 lakhs 93,325.
All right. We say no.
Plus interest at the rate of 12%. So and so. So it
what is your explanation for the delay? Let's see that.
77 days delay only.
How many days delay? 80 days.
Lordship may admit this because delay is very.
Or only writ appeal as well as application for consideration of delays in notice returnable.
Supplementary list item 54.
54 manner, no instruction manner.
No instructions.
Item 55.
None appears dismissed.
Supplementary item 56.
56 for, if I may please your lordship, my lord.
What's the delay?
My lord, I couldn't hear your lordship.
days. 18 days. All right. Yes. The delay is controlled. What's the matter?
My lord, the order under challenge is that wherein the appellate authority has terminated my appointment. My lord, may kindly have annexed.
Anganwadi worker.
Anganwadi worker, your lordship.
Saying that you're not a resident of that area.
My lord, that is the stand, that is the reasoning that has been given by the learned appellate authority. My lord, may kindly have page 13 of the writ petition, your lordship. My lord, this is there in ODIA. My lord, just ask me kindly help me out, my lord. My lord, page 14. My lord, in an Anganwadi center in a particular village, what happens is if there are if the number of students exceed that area, so they subcategorize that one Anganwadi center into 1, 2, and 3. So, my lord, what is under challenge is the Hingul 3 Anganwadi centers appointment, your lordship. My lord, at page 14, your lordship would kindly see serial number 17.
Yes.
Serial number 17, the village name is Hingul. Then the centers known
Hilung or Hingul?
Hingul. Hingula.
I don't know.
Hilung. I'm sorry.
Hilung. That's what I thought.
I'm sorry, my lord. Hilung. And then the center is Hilung 3. And then, my lord, the area has been demarcated as to from what area it would be. It is schools.
Look this.
My lord, may I continue?
No. So what has happened in the meanwhile? Status quo here.
My lord, there's no status quo granted. My lord,
no, there's an interim stay here. No. Acha, there.
My lord, it was there in the writ appeal, in the writ petition, your lordship.
So
after my cancellation, my lord, this person is continuing, but my vested right still continues, my lord. My lord, because I was appointed. My lord, I'll just establish that.
How old are you?
My lord, at present, I am 29, 22 plus 7, 28, 26, 28, 29, my lord.
Okay, take a chance. It's a notice. The delay is condoned. It's returnable. 13th December.
My lord, may I pray for us?
Now, not now.
My lord,
At this
I'll leave
stage,
it
how
to
to
lordship,
do?
my lord, because for the last 7 years, my lord, I've been deprived, your lordship.
So how can you get back now? There is an interim order some years ago that I can understand. Yes.
I bow down, your lordship.
Yes.
Extremely grateful.
Item 57.
What's the delay?
32.
All right. 57. None appears dismissal not prosecution.
Item number 58.
None appears dismissal not prosecution.
Item number 59.
59, we challenge for the Honorable Single Judge in a writ petition with regard to grant of LPG retailership in favor of the respondent. The respondent filed a writ petition for grant of clearance and operating the same. 2 writ petitions were allowed. 2 writ appeals have been preferred. One is before your lordship on board. The other is writ appeal 112 of 2015. Your lordship may dispose of both the cases because 7 years have elapsed. In the meantime,
due to passage of time,
that may be
the
taken
appeal
on
has been rendered infructuous and is disposed of as such. Taken on board a special mention, writ petition 111.
112 of 2015.
112 of 2015, in view of the dismissal today of writ appeals 168, this appeal is also dismissed for the same reason. Right.
Nice.
Item number 60.
Ma'am, please, your lordship, I'm appearing on behalf of my learned senior, Mr. Bhuya. Your lordship, this writ appeal has been rendered not maintainable as per the Supreme Court's judgment in Jogender Singh Ji versus State of Gujarat, your lordship.
Give us the citation. Counsel for the appellant states that in view of the decision of the Supreme Court in Jogender Singh Ji versus State of Gujarat.
2015 SCC. 2015 SCC, volume 9, page 1.
2015 9 SCC 1. The present appeal is not maintainable. It is dismissed as such.
Much obliged, your lordship.
Item 61.
None appears dismissal not prosecution.
Item number 62.
62 infructuous.
Infructuous dismissed.
Item number 63.
My lord, may be permitted to withdraw.
Withdraw. Counsel, the appellant seeks leave to withdraw the present appeal. Dismisses withdrawn.
Supplementary item 64.
May I please, your lordships? Here, my lord, the appellant challenges the impugn order of the Honorable Single Judge onto Annexure 3, my lord. Order dated 2/4/2015, my lord. Order dated 2/4/2015 passed by the Honorable Single Judge is under challenge, my lord. What has happened? The matter is like this, my lord.
Anganwadi worker.
Anganwadi worker, my lord.
Harihar-pur Anganwadi Center.
My lord.
So you are not a resident there?
I am the resident, my lord.
No,
The respondent number 4 is not the resident of Harihar-pur Anganwadi Center, my lord. For which her residence certificate was held by the respondent number 3, my lord.
Okay.
Against that, the respondent number 4 preferred appeal before the respondent number 1, my lord. That was also dismissed, my lord. Against that, the respondent number 4 had preferred again appeal before the IDA. But Honorable Single Judge has passed the impugn order, setting aside both the orders of the respondent number 1 and 2 respectively, my lord.
So she's working there now.
After the impugn order passed by the Honorable Single Judge, my respondent number 4 is continuing there, my lord.
All right. You are for respondent number 4.
I am for the...
But no copy has to me. I have appeared so what will.
So notice, he accepts notice for respondent number 4. Mr. Mohanty accepts notice for 1 to 3. List for hearing on 12th January.
Supplementary list item 65.
So direct copies may solve me.
Yes, I will solve in course of that.
Item number
Excuse me for 60, my lord. Just now I come to know I have lost this sight of the list, my lord. So to that extent, may kindly tomorrow or day after, as your lordship think fit, my lord.
PIL, sir.
No, correct, madam. I have not gone through that list.
We'll help you, sir. We'll help you.
Maybe I have not gone through. It was infructuous. By eclipse time, IPS lease was granted. It was in 2016. Now we're in 2022.
Passage of time, the subject matter has been rendered infructuous. The petition is disposed.
Lease period is already expired.
The lease period is having already expired. The subject matter has become infructuous. It's disposed of.
Much obliged.
Item number 66.
My lord, it became infructuous.
Infructuous dismissed.
Item 67.
Please. In this case, it is a plain matter. In this case, the petitioner has filed the case for a construction of one Kalyan Mandap in one place, but due to the political rivalry, now the opposite party, that is the opposite party number 6, 5 and 6. Now they are going to construct that.
Going to? This is a 2017 matter, sir. What is going to?
But neither they have constructed till date that has been.
Then don't worry at all, sir. If they're not constructed, that will be the end of the matter then. Due to passage of time.
The place where the central Kalyan Mandap should be constructed, that has been decided.
Para 3 of the counter affidavit. Para 3 of the counter affidavit. Since steps have been taken for construction of Kalyan Mandap in a suitable place other than the site demanded by the petitioners, there is no illegality or infirmity in the impugned letter so and so under annexation.
No, he says there's no Kalyan Mandap yet constructed.
Yes, ma'am.
We keep preserved.
Till that has not been constructed. So far, my client's knowledge is concerned.
All right. Counsel, the petitioner states that as far as his knowledge goes, no Kalyan Mandap has yet been constructed. In that view of the matter, it is premature for the court to entertain the present petition. It is disposed of as such.
Item number 68.
May I please, Your Lordship? My Lord, this is a matter regarding the illegal dumping on the road, which is very closer to the airport, Bhubaneswar Biju Patnaik Airport. And secondly, it is very close to the Hajj committee and also to a masjid. They are illegally blocking.
What is it construction?
No construction. Only they are dumping the waste material on the way. I have
This is filed in 2019, sir.
Yes, my Lord.
My Lord, as per instruction, I am for BDA, my Lord, on behalf of Mr. Mahapatra. As per instruction, my Lord, already all the wastage materials were shifted by the contractor.
No, my Lord.
And there is no wall already constructed, my Lord.
No, my Lord, nothing.
As per instruction, my.
How do you know? Why are you saying no?
Yes,
when did you visit the place?
On the previous Sunday.
Where is the photograph? Can you show us a photograph?
The recent photograph?
Yes.
I have not placed. I will place
you place it. You place it. Counsel, the petitioner wants to place a recent photograph to say that the problem of dumping of waste still persists. At his request list on 11th October.
My Lord, in this case, I'm appearing for BMC. I filed my counter saying that it is just a temporary and a transitory garbage collection from the houses. Thereafter, it is taken to a material recovery facility.
Let him show the photograph. We'll see how bad it is.
Okay.
All right.
Item 69.
Item 69, the face criminal appeal or admission.
Admit the trial court record be requisitioned. Thereafter, paper books be prepared within 8 weeks and supplied to counsel for the parties. Thereafter, the appeal be included in the list of final hearing matters. This 1503 of 2022, you say there shall be a stay of recovery of fine during the pendency appeal. What is how many days has he been in custody? Bail application. How long has he been in custody?
Since date of judgment, man.
Which is?
Judgment 13/7/2020.
So you say bail application is not pressed at this stage. All right.
Supplementary list item 70.
Same order as yesterday's. Yesterday there was the same order.
Same. 5th January 2023.
Item number 71.
Millard, in this case, I am for the petitioner, Millard. I am challenging the order of opposite party number 1, the Principal Secretary Panchayat Raj and Drinking Water Department, Odisha, Millard, order dated 27/7/2022, which is not in consonance with the factual report of the District Rural Development Agency Annexure 5. Millard, the relevant persons I am reading. Your Lordship may kindly have a glance on page 41, Annexure 5. Sir, inviting a reference to the letter and subject cited above, I am submit herewith a detailed factual report on the road condition of the road as mentioned in WPC PIL number 38496 of 21 as under. That the BDO Bhadrak was requested to submit a detailed factual report on the aforesaid matter by this agency, letter number so and number so and so, dated 17/3/2022, pertaining to the order of Honorable High Court and letter of PR and DW Department under reference. Accordingly, the BDO Bhadrak had directed the AE and JE concerned to the block to conduct a detailed inquiry on the matter and submit report. They have submitted the detailed inquiry report on the matter which are as under. That as per their report, the length of the road is 202.50 meters, which is severely damaged for many numbers of potholes, patches, stripes, not suitable for vehicular movement. They have also reported that construction of the protection wall near the pond is required to protect the road. If the repair and reconstruction of the road will be taken up, the main road of the village will be suitable for vehicular movement and transportation of paddy from paddy mandi to rice mill during the procurement period. As for their estimate,
who's appearing for this? Panchayat?
For government.
No, government will be appearing. They basically passed the buck on to the local MLGA, saying the district, the existing fund in the district may be utilized. That's what the decision is.
They have no funds, Millard.
No, 1 minute.
Paragraph.
1 minute, sir. Let me ask him a question, sir.
Page 44.
Sorry, Millard.
Your Lordship is referring page 44.
That's right.
Yes.
This is just passing the buck, not having any timeline for when we will complete the construction of the road.
Because all these are to be taken up by district level officers.
Whatever. From a citizen's point of view, no point in pushing him from one to the other.
It is a small village in a panchayat.
Yes.
And whatever...
road matters to them, sir. All small villages, the roads matter to them. Somebody has to take the call and finish the work.
I'll take instruction.
Notice, Mr. Mohanty accepts notice and seek instructions on when the road in question can be completely repaired and set in order. An affidavit to this effect, giving clear timeline, be filed before the next date. List on 29th November.
Supplementary list item 72.
Pray for a Passover, my lord.
All right.
Item number 73.
None appears dismissed in opposition. Oh, Niranjan Patnaik. One.
Millard, I am appearing for item number 73.
What is this?
My lord, before he starts, may I just clarify to your lordships? My lord, this has been filed by setting up the petitioner. Because two writ petitions challenging the tender procurement of books for supply to the school. Two writ petitions were filed. Those writ petitions are still pending in the assigned court.
Oh, I see.
No stay order was granted.
Oh.
Thereafter, it has been filed. In the meanwhile, all suppliers have been provided orders and they have been supplying the books to the schools.
Oh, I see. There's no need to entertain another one.
Millard,
There's no need to entertain a PL.
Millard, may I submit, Millard?
Yes.
Millard, I'm deeply aggrieved by the submission of the Lord Senior Counsel. A petition is filed and a petition is always supported by documents and is also a relief is sought for in the court that is called prayer. The petitioner is a journalist. He came to know about the procurement of the books from the printers, from the binders, from the suppliers and the shop owners for the procurement of books regarding the Samagra Shiksha. That is a scheme launched with the joint collaboration of the center and the state government. The over anxiety and the jealousy of the state government is apparent on the face of the record and telltale because before making a submission by the petitioner, the question starts, it is a setting up. How it is not setting up, how the government has a dark face. The state education
is the backbone of the nation. If we educate a child, we educate the whole nation. The books are selected by a panel of the learned person and educational luminaries. The books are selected from the suppliers. The government of Odisha published notification for the publication of the for procurement of books, inviting an expression of interest under the Samagra Shiksha. That is the Milord at Annex 2 series. That is the purpose of Samagra Shiksha. I am saying that the central government has launched an integrated scheme for school education named as Samagra Shiksha with effect from 2018-19. Under the integrated scheme of Samagra Shiksha, library grant is one of the major interventions for improving quality of education, which includes provision for library and books across all levels of school education. To improve the educational system, the nationwide debate is the load of the school bag, the load of the midday meal scheme, and here it says that under the Samagra Shiksha Abhijan, the three erstwhile centrally sponsored schemes have been submerged. That is Sarva Shiksha Abhijan, Rashtriya Madhyamik Shiksha Abhijan, and centrally sponsored scheme, that is teacher education, under the Samagra Shiksha. And this matter is regarding procurement of the books under the Samagra Shiksha, that is a scheme launched by the central government, and it is run by the joint collaboration of the central and state government. An integrated scheme on school education, Samagra Shiksha, has been launched to universalize quality education. This is a nationwide debate. While I was reading in Delhi, I have done enough research on that matter. Financial year 2018-19, and starting from the school education, that is pre-primary, primary, upper primary, and secondary or to higher secondary levels, the scheme therefore attempts to provide an integrated composite school system from preschool to higher secondary level. The government has a black face, and the manipulation of the state government. Milord, we trust the state. Lordship always trust the state. The state is for the welfare of the people. We exist because in a welfare state, the welfare of the individual is the welfare of the state. It is not a communist state, Milord. The individual, the liberty, the right, and the liberty of the individual is everything. And education from because of the importance of the education, right to life, Article 21A has been a fundamental right that has been inserted in the Constitution. Milord, Lordship will see the government has launched a scheme that is, Milord, on 30th March 2022, government has invited expression of interest for procurement of books from local book publishers, publishing houses of Odisha towards procurement of class age appropriate library books. Under Annex 7 series, at page 148, I am a journalist, Milord. Under Annex 10, there is a newspaper item. Because of that, I collected the information. Lordship will see on the face of the record, duly process and offset. The printer is directed to supply the books. The next is Panchajanya Press. Press has been directed to supply the books. Next is Vrindavan Suppliers. One supplier has been directed to procure the books. And Bajrang Traders, it has been directed to supply the books. The illegality is apparent on the face of the record, Milord. The illegality is apparent on the face of the record. Chhatrashakti Press. Next is Press. Where is the local publisher? Where is the local publishing houses? Where is how the books are procured? Then the question is, Milord, how the books are procured? Is there any precedent that how the books have been procured under the Samagra Shiksha Abhijan? I have annexed the document at Annex 8 series that how in the past.
So when did you give your representation?
Milord, since on the basis of the newspaper item at Annex 10, that is at page.
When did you give your representation?
Page 207, Milord. I came to know about that. So I am being a journalist. I straight away filed a petition.
When did you give your representation?
Milord, subsequently, I have given a representation that is on 7 September 2022.
And today we are in what date, sir, today?
Milord, only thing is that.
1 minute, sir.
Milord.
You saw this advertisement in March.
Milord.
You waited for 4 months to give a representation. Not 4, 6 months. March advertisement, in September you suddenly woke up, you said, I'm giving representation on 7th.
On 7th September, my lord.
Today is what date, sir? And my memory is weak. I'm asking you.
20th September, my lord.
How many days, sir?
My lord, only thing is that only.
No, no, tell me. Just arithmetic also I'm weak.
14 days. 13 days, 13 to 14 days.
Your arithmetic is better than mine. So in 13 days, you want everything to be decided.
My
the government.
My lord, because there is my matter was not listed because I have not given. There is the provision of the PL because I have. Because of the urgency, I have filed it, my lord.
So you are a very responsible journalist. So we expect you to be responsible in this also. Follow the rules of the court.
With the lordship's permission, my lord, only 1 month, 2 month times given. Only it will be over. That is why I was.
If you're so responsible, you should move in good time. All right. It's not that today I have woken up. Today I must get relief.
Only thing, my lord. Only thing, my lord. The printers, binders, suppliers are allowed to provide the books to the students.
Wait to see what happens in your representation. You have to wait for some time.
Lordship, direct me to. Lordship,
the petitioner has given a representation only on 7th September 2022, and that too after the defect was pointed out by the registry. He had filed this petition even before making such a representation, which was mandatory as per the PIL rules. Full stop. Without waiting for a response to the representation, he wants the court to intervene in the matter. Full stop. Considering that not even 2 weeks have passed since he gave his representation, it is premature for this court to consider the present petition. It will be open to the petitioner to follow up with the government on his representation and then seek appropriate remedies in accordance with law. The petition is disposed of. Right.
Supplementary list item 74.
May I please, your lordship? My lord, the present petition because this writ application in shape of public interest litigation lordship and file seeking direction to this honorable court, my lord, to dispose of the representation Chapter 2, page 12, my lord. Till that, my lord, they have not considered the petition grievance lordship regarding shape of the dirty land, my lord. Now, my lord,
what is there to show that this representation was delivered?
My lord,
what is there to show that this representation was delivered?
My lord, Mr. to deliver lordship of send receipt. Delivered, my lord, 11/4/2000, but receipt I haven't received.
You file a fresh representation, permitting the petitioner to make a fresh representation. And after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of.
Supplementary list item 75.
My lord, with stipulated time may be lost filing of this.
Yes.
75.
May I please, Lordship, the current writ petition under the form of PIL was filed because of inaction of the opposite party number 2, 3, and 4 while considering my representation for protection of the village forest, your Lordship. I have made the said representation in 24th February, your Lordship, 2022.
All right, for petitioner's representation, bracket annex 3 series, be considered by opposite party number?
Opposite party 4.
4. I'm giving notice to the petitioner as well as petitioners as well as opposite party number 5.
And any other encroachers, if
and any other alleged encroachers. And after giving them a hearing, a reasoned order shall be passed thereon not later than 19th December 2022. The order should be made available to the parties within a week thereafter. The court clarifies it as not expressed any view on that.
Supplementary list item 76.
May I please? The impugned order or annexure 4 were passed by on single judge order challenge for lordship, my lord, wherein the prayer for direction to
you
the
have not filed a certified copy of the impugned order, sir.
The impugned order under annexure 4 certified copy has been filed.
The defect is that you have not filed certified copy.
That is filed at the time of filing, my lord.
So there is a defect. If you look at the notice,
yes, my lord.
The cause list itself, it is indicated you have not filed.
I undertake to file, my lord, within a week.
Canteen boy under the United Bank of India Canteen Committee.
My lord.
So,
the petitioner was working since 1994 and Annex 1, my lord, circular of the bank came in the year 2010. As you can see, page 10 of the page 12, my lord, Annex 1, my lord, wherein the banks issued the circular that the canteen boy who have already rendered 8 years of continuous service, they will be regularized, my lord, and accordingly, my lord.
But you were engaged by a canteen committee, sir,
Canteen
not by the
committee.
bank.
Yes, my lord.
So how will the circular apply?
Lord, you can see the canteen committee eligibility, my lord, the canteen boys who have worked for not less than 80 years as on date of issuance of the circular in any canteen run by a committee of the employees of the branch / office of the bank, where at least 25 numbers of employees are posted, will be eligible for applying. So I have been appointed under Annex 2, my lord. Lord, you can see Annex 2, page 14, in the year 1994. For a remuneration of 350 rupees per month. And Lord, you can see respondent number 4, who is pretty junior to me, he has regularity in the post of sub-staff of the bank.
All right, it's a notice returnable. Counsel for the appellant undertakes to file a certified copy within a week of the impugned order within a week. Notice returnable 11 January.
Obliged.
Item 77.
My lord, I'm seriously ill. It took time, kindly be allowed. My wife is also seriously ill. Myself is ill.
What is the matter?
Affected with diabetes. Took time, kindly be allowed. Item number 77, my lord.
Counsel for the appellant seeks 2 weeks' time to file a certified copy of the impugned order. List on 17 November.
Supplementary list item 78.
May I please your lordship, my lord? My responsible submission is due diligence, my lord. Here the Lord and Single Judge order dated 9 February 2022 by the Annex 1 is challenged, my lord. My responsible submission that the Lord and Single Judge only targeted the suit pending before the Lord and Civil Judge Senior Division Jajpur Road, my lord, but without determining my point of law, my lord. So I humbly submit those matters raised before the Lord and Single Judge will also raise before the trial court, and trial court will decide on merit.
Against an order under Article 227.
Yeah,
CMP
no
order.
appeal is maintainable.
Yes, CMP order.
The present appeal is not maintainable as the impugned order was passed in exercise of the jurisdiction of the single judge under Article 227 of the Constitution, leaving it open to the appellant to seek other appropriate remedies. In accordance with law, the appeal is dismissed.
79.
My lord, so far the 79 is concerned, my lord. My representation by Annex 3 mile is pending before the collector Kendrapada. That may we consider, my lord. That was registered.
Appeal. What is this writ appeal about?
My lord, so far the writ appeal is concerned, the order of the Lord and Single Judge by Annex 4, my lord. Please make a glance. Order dated, my lord, 6th 7 2020 challenge. Lord and Single Judge passed order by Annex 4, my lord. Please make a glance.
Yeah, it's not maintainable, sir. It was not maintainable before the single judge. How is this maintainable here? And you wanted to withdraw it.
My lord, I want to withdraw, and my representation may be considered.
The impugned order notes that the writ petition stands dismissed as withdrawn.
But
the
my
court sees how the court fails to appreciate how any writ appeal can be maintained against such an order.
My representation may be considered. No. For sake of the interest
The appeal
of
is accordingly dismissed. Sorry, sir. Yes.
Supplementary list item number 80.
May I please, Lord? In fact, there is a defect for not furnishing the correct provision in the constitution. And also there is delay of 180 days, I admit that. But there is substantial question of law involving this matter.
We leave it open, sir. You say delay 180 days has not been properly explained. Accordingly, the application for condition of delay is dismissed.
I may be permitted to place one judgment to lordship, subject to lordship's consideration.
The question of law is, however, left open for decision in some other case. The writ appeal is accordingly dismissed. Yes.
Supplementary list for orders item 8.
Item 81, may I please, my lord. An IA for interim bail on the ground of the first death anniversary of the appellant's mother, my lord.
I've got instruction.
It is there.
Yes, my lord, it's there, but there are other things which.
Yeah.
Earlier, the appellant was released on interim bail at the time of death, my lord. And
Death
he
is
has,
different from death anniversary, sir.
my lord. And
You
he has
can't treat the
surrendered
same.
duly after that, my
You
lord.
can't treat both the same. You're facing a 302, correct?
Yes, lord.
Ah.
The only son, the pretend being the only son, my lords. Lordship is aware, Hindu
Yes,
rights and
whatever.
customs, my lord.
No.
Placing on the ground
The
of
complainant is
compassion.
anticipating danger to his life. We're not inclined, sir. Having perused if you want to withdraw, you withdraw. Otherwise, we'll record this.
I may be permitted to withdraw, my lord.
The IA number so and so, counsel for the applicant does not wish to press this application. Dismissed as withdraw. Right.
Great.
Item 82.
82, may I pray for adjournment?
Is it admitted?
Yes, it was admitted, the paper book may be called.
Yes. Has it been admitted, sir?
Admitted, already admitted, and LCL confirm, may I pray for 1 week after, my lord.
The paper books be prepared and supplied to counsel for the parties within 8 weeks. Thereafter, include in the list of final hearing matters. Yes. Stay of fine, that fine is stayed, then bail not pressed at the stage. Right.
Item number 83.
My lord, item number 83. As per SR, there is some defect, my lord. Require some time to clear the.
All right. Is it admitted or not? Admit. The LCR will got for. Paper books be prepared within 8 weeks. What is the defect number 9? All right. You see, meanwhile, the defect pointed out was raised to be cured. After preparation of supply of paper books, the matter be included in the list of final hearing matters. It's IA, you just say stay of realization of fine 1470 of 2022 is allowed. 1471 for bail not pressed at this stage.
Supplementary list item number 84.
And then you just say admit. The will be called for the paper books be prepared within 8 weeks thereafter and supplied to counsel to the parties. Meanwhile, defects as pointed out with to be reported. To be included in the list of final hearing matters. IA 1476 for realization fine that is allowed. 1477 not pressed at this stage.
Supplementary list for admission item 85.
85, Lordship, just now he has sought the copy
I
of the
have filed
counter.
counter affidavit and just now I sought a copy of the counter affidavit.
What's the matter about Alex?
The matter is not that that this is a case, my lord. The opposite party number 4.
Possession of vehicle.
Yes,
my lord.
They have आज and date, my lord, I have handed on last occasion the RC copy. The Lordship remember that is आज and date stand in my name. So, my lord, as per the order, my lord, it is pending and similar. What he has done to my, I am ready and willing to pay the amount and release the vehicle. That was the issue before this honorable court, my lord. Before this consumer court, directed to proceed. And thereafter, my lord, he has not heard the matter. Therefore, before Lordship is to notice. And after some years, my lord, after forceful direction to this honorable court, he has filed the counter and just now he has served the copy to me.
No, what is your stand? What are you saying?
My lord, the vehicle was repossessed due to default in making payment of the installment dues. And prior to filing of this writ petition, my lord, the vehicle has been sold. That I have stated in my counter affidavit.
The RC is still in his name, he says.
Millard,
The RC is still in his name. How did you sell the vehicle? Anyway, when did you sell it?
that was on 2011, my lord.
Then there's nothing left in the matter. With
Your
no
Lordship,
point in holding on to
Millard,
these matters.
Millard,
Now you seek other remedies.
26/12/2011 vehicle was sold.
Millard, he is not naming whom he has sold the.
That you can find out. It's all right. It's on 2011 sale. Who's going to chase it now?
Yes.
Give us a copy of the counter, sir.
That has been filed, my lord.
Give us another copy.
Yes, I have it.
From the counter affidavit filed by the opposite party number
4.
4. It appears that the vehicle in question was sold way back in 2011 itself. Consequently, the court sees no purpose in keeping the present petition pending. It will be open to the petitioner to seek other appropriate remedies as may be available to the petitioner in accordance with law. The petition is disposed of.
Lordship, kindly say he is not naming whom he has sold. That observation, Lordship, he is not naming whom he has sold.
So it will be open to the petitioner to approach respond before to get details of the person to whom the vehicle has been sold.
Your Lordship.
All right.
Supplementary list item 86.
86 not here. Here is a the dispute arises upon the proceeding under the Orissa Cooperative Societies Act law. Now under Annexure 4.
How is this writ appeal waitable?
Challenging the report of the inquiring officer, a revision was preferred against that.
That's a 227, sir. Once it's a revision and then comes in a writ petition, it's a 227.
Now, what I beg to submit now, and without going to the merits of the case, let's me kindly have a glance at the counter affidavit file at page 3 of the counter affidavit. Let's me kindly have a glance. After the same Annexure 4, the inquiry report, 5 numbers of dispute cases have already been initiated by the ARCS, Assistant Registrar, and those are still pending, they have indicated. So, giving us the liberty to raise all those questions there, that is the proceeding on 65 also.
All right. Counsel, the appellant seeks leave to withdraw the present appeal with liberty to raise all the issues raised in the present appeal before the Assistant Registrar.
Assistant Registrar, Cooperative Societies.
Cooperative
Kindly refer to para 8 of the counter affidavit. The numbers are there.
That's okay. In the proceedings stated to be pending there as per para 8 of the counter affidavit. Is it disposed of as withdrawn with liberty is grateful.
Right. My lord, I am appearing for the respondent number 3, my lord.
All right.
My presence may kindly be recorded.
Okay, sir.
Item number 87.
Connected lordship, deed application 3803. I have filed a PIL mail on behalf of the villagers.
What's the matter about?
Matter lordship, the Jaleshwar municipality.
I may first.
Yes.
This is a grievance of the nearby villages of River Subarnarekha. It is that on their several the government is not taking steps to remove or demolish the two unauthorized wooden constructions.
What constructions?
Wooden construction.
Wooden bridge.
Wooden bridge in the river. That has been at page 26, annexure 7, a joint verification was made. And they have found that it is two bridges are constructed illegally. And there I have filed a additional affidavit.
Why are you not removing the bridges, sir?
Lordship, Commission Lordship, I am representing 15 Gram Panchayats. There are 2 wooden bridges. Now the villagers of the 15 Gram Panchayats are depending upon that wooden bridge. The allegation,
I'm coming to that
bridge, Lordship,
they are against each other. I'm coming to that, my lord.
There are the allegation, Lordship, that the sand mafias are using that wooden bridge. If that be so, Lordship, let the police is there below. Let the police
against the mafias.
Additional affidavit, I have given some photographs.
Correct. The point he's making is if there's a bridge, let it be used by the villagers. If
that is what
illegal mafias are using it, it's better to go against illegal mafia rather than remove the bridge.
For lifting of sand. There is some pathway to go over the outside river, but they are using this.
Once the villagers started using a bridge, you can't remove it.
No, my lord, that is the wrong conception they have given, my lord. They have mafias, those two bridges constructed by the mafias, and they are using those.
It's all right.
Yes.
Mafias are also using the main highways also, sir. Can you dismantle the highways?
Your Lordship can have a glance to my additional affidavit. Have a glance to additional affidavit.
Yes.
At
the photos, Annexure 11 series.
Yes. Annexure 12, the Tahsildar has passed an order at page 14, passed an order to demolish the same. But they have, on other way, they have come on 5317/2020, they have taken the stay order. Therefore, they cannot remove it. It is
My lord, so far as this illegal lifting of sand by so-called land, this matter is seized in a proceeding before the NGT.
NGT.
That is,
yes.
That is there. Yes, that is there. And
well, what is that proceeding? Give us that.
Yes,
that
NGT has disposed of this matter on 2/2/2022.
Oh, recently.
Recently.
Okay.
Oh, they have disposed it off.
Yes,
OA number
and they have prepared the guideline to how to maintain it.
Then
that is what I am saying.
And
that wooden bridge has to be there, and it should not be used by land affairs. There is no dispute on it. But that is a matter which has already been dealt with.
Conflicting issues. One raised by the petitioners in writ petition civil 2021 of 2020, stating that a wooden bridge over the Suvarnarekha River in Jaleshwar should be dismantled, as it is used by the sand mafias.
Jaleshwar municipality.
Jaleshwar municipality.
As
it is being used by sand mafias. The opposite point of view has been projected in the connected writ petition
3803
of 2020 by the villagers who want the bridge to remain as they are using it. Paragraph. It appears that in the meanwhile, the National Green Tribunal Calcutta bench has already issued detailed set of guidelines on 2nd February 2022.
OA number 33 of 2020.
In OA 33 of 2020, which apparently applies to the issue of illegal sand mining from the banks of the Suvarnarekha River. Therefore, this court need not entertain another petition on the same issue. Per paragraph, as far as the wooden bridge being used by the villagers is concerned, the court is not inclined to entertain a prayer for its dismantling if in fact it is useful to the villagers. Accordingly, these writ petitions.
Your Lordship can joint inspection report should be referred to, because the joint inspection says that it is an illegal construction, not by the village.
Your Lordship may opine that it is open for the state government to take a decision on this, because whether we will dismantle, because it is a road, it is a connected road. So if there will be any proposal for any concrete bridge, then it is to be demolished.
Lordship, in my case, representation is pending before the district magistrate, Annexure 2.
Right. Apparently, for the construction of a regular bridge, there's already a representation by the villagers, which is pending with the state government. It will be for the state government to take a decision thereon in accordance with law. What is this writ appeal?
One writ appeal is there.
And your Lordship will dispose of that
Lordship has just now passed
5317
order in the connected matter. Our purpose will be solved, my lord, with that order.
All
Lord,
connected
both in
matters are
writ petition
disposed
number
of.
5317 of 2020 and as well writ appeal number 322 of 2016. Lordship just now passed the order that will serve our purpose, my lord, in the connected writ petition.
Or you say the connected writ petitions and writ appeal are accordingly disposed of.
And writ appeal may be disposed of.
Lordship, online submission, Lordship, before consideration, I may be allowed to.
All right. Yes.
After hearing
yes, Miller.
All right.
After hearing all the petitioners, all parties.
Then there will be no end to this.
All right.
Item number 88.
Your Lordship has given direction to collector to
the state government, sir. We're not set collector.
Yes.
All right.
But no counter has been filed.
Yes.
And your Lordship directed this matter to be taken up along with WPC number 4739 of 2022 on 24th January.
All right.
So
List along
with the meantime, the counter may.
All right. List along with
4739 of 2022.
4739 of 2022 on
24th January
24th January 2023. Replies be filed in the meanwhile.
24th January. There are 3 cases.
Second matter is concerned
So-
also arising out of the same notification that may be taken up along with that.
All right.
Sir, I'm appearing on behalf of Mr. P.K. Rath. We are for the petitioner. Kindly adjourn this matter.
Yeah, we've already
Yes,
done
that is already adjourned.
All right. Yes.
Item 89.
My sir,
please, Your Lord.
interim order to be continued.
All right. Interim orders to continue. All right.
Bless.
Item number 89.
May I please, Your Lordship?
Yes.
Here, Bharat Petroleum Corporation is the appellant in the writ appeal. I am aggrieved by an order passed by this honorable directing me to pay amount which was filed by the petitioner, his claim after the counter was filed, a money claim in the writ application. I am aggrieved by that. Facts like this.
Which
This
is where is the impugned order, sir? Which page is the impugned order?
Yes, Your Lordship, may kindly see. I have given the judgment, Lord. It is at page 51, Lord. If Your Lordship will kindly see at page 54. Admit position is the oil company not contract to the petitioner. First. Then Your Lordship will kindly next page. Para 10, the oil company will pay compensation to the petitioners of rupees 4,61,376 with simple interest rate and so and so, so and so. And Your Lordship will see para 9 constitutional Stone, this is Lordship well known in the case of Joseph Technologies and also in various other decisions. If a contract between a private party and the state instrumentality and or agency of the state is under a realm of private, there is no element of public law. And there is also no contract with me at all. There are two dear. With the opposite party. I also disputed the amount by filing a counter.
Mr. Das. The fact remains that you don't need the land anymore.
We have removed the equipment, my lord. We have removed the equipments totally.
Long since have removed. But Your Lordship, kindness, the honorable to the judgment, I have given the copy of the judgment. Your Lordship will see para 7, 8. If between the private party and state instrumentality and or agency of the state is under realm of a private law and there is no element of public. The normal course for agreed party is to
Sir,
invoke the remedies provided under this.
Mr. Das, if you want a stay of this order, you're going to have to deposit that entire amount with interest here. This amount is not substantial for something like in Bharat Petroleum and all. This is not a substantial sum.
Substantial, but on the point of law, my lords,
We can keep the question of law open, sir. If it is a very substantial sum, we could have entertained it. It's not a very substantial sum from Bharat Petroleum's point of view. We can leave the question of law open. We can leave the question open for decision in some other case.
But I will not pay to him.
Then you deposit in court and let him wait. You also wait.
Yes, I will deposit. I have no objection to deposit in court. I will deposit in court before your lordship's court.
All right. Subject to the appellant depositing the sum of rupees 461,376 along with interest at 10% per annum from April 2017 till the date of deposit in this court, not later than 1st November 2022. There shall be a stay of the impugned judgment of the single judge till the next date. You say notice, you accept notice for 1 and 2.
No, I am supporting Mr. Das.
Oh, I see. Notice returnable. December 5th.
The contempt order stay is there. That
the amount deposited in this court shall be kept in a fixed deposit.
The Honorable Court has directed
the Nationalized Bank initially for a period of 6 months and shall be kept renewed till further orders by the court. There's already a contempt petition. Where is that?
There is a contempt petition stay has been granted.
There shall be stay. Once it's stayed, the impugned order itself, there's no question.
Obligation.
So blessed.
Supplementary list item number 90. Item 90.
There is no delay, madam. This is during COVID period.
All right. During
Delay
COVID
to
period.
70 days lordship.
During COVID
period, it's all right. This delays during the COVID period and therefore it's condoned. The IA is disposed of. That dispensing with certified copies also. What is the matter about?
This is matter regarding the promotion during pendency of criminal case.
When is that coming up?
You'll also be fixing it to 28 October.
But in this case, this is already over.
Notice to the opposite party. List on 28th October. There shall be a stay of the impugned order till then.
Let's say my appearing. Let's say
91 also says.
Right.
Both are same.
91 also same. All right.
Item 92.
This is a PL regarding fiscal irregularities, and the collector came out with a specific finding about the irregularity, how the money has been siphoned, and thereafter they filed the FIR saying that there is no clue about that, my lord. I want to file a short rejoinder to the counter, my lord.
There's already a counter.
Yes, they have filed a counter and 18 counter dated 18/7.
Investigation, and
where is the counter?
That's
not on record.
Whereas the counter was filed on 18th of June 2022. Counter affidavit filed by opposite party number 4. The IIC has.
It's there. Not bookmarked. All right. Rejoinder to be filed before the next day. It's on 5th January.
Check on the password.
Fixing
Password matter item 11.
May please, my lord. I'm not wasting lordship's time, lord. You lordship may straight away look at the judgment, my lord.
Yes.
My lord, the fact is that the Honorable Single Judge has not accepted our submission that a registered lease deed for 40 years is as good as sale, my lord, and the ownership is passed, my lord. That is the point, my lord. And that section 109 of the Transfer of the Property Act, my lord, your lordship may kindly have a glance. Lord, section 109, my lord. 109 is right of a lessor's transferring. if the lessor transfer the property leased or any part thereof or any part of his interest therein, the transferring in the absence of a contract to the contrary shall possess all the rights, and if the lessee so elects, be subject to all the liabilities of the lessor as to the property or part transferred, so long as he is the owner of it. Has your lordship got it?
Mr. Mohanty, but this is a appointment made pursuant to advertisement in 2015.
Yes, nothing.
Now the whole parameters must have changed, sir. You can't insist that you will still be appointed as distributor pursuant to that advertisement of 2015.
No distributor has been appointed in respect of the outlet till then.
Page 53, yes. I think my learned friend is not correct in submitting so. G, class G, page 53.
No, I am coming, Mr. Acharya, I seek your indulgence. Please wait. Then, my lord, the second point is that your lordship may kindly have a glance at page 73. Has your lordship got it? No?
Yes.
Well, this is the checklist prepared by the department, my lord. Well, particulars, column number 9. This was given in the counter, my lord. Physically verify the land for go down as mentioned in the application. State the dimension of the pen. Supporting documents to be verified. Has your lordship got that?
Yes.
Registered seal deed, mutation, gift, lease, 15 years minimum agreement, and government record, etc. Then, my lord, the reason for not giving the dealership is that original documents verified as per application, applicant has declared ownership of land while registered sale deed, gift, denotation, record of dated for khata number ete. On verification, it was found that no registered sale deed mutation available with the applicant, but the applicant has a registered lease deed number dated as per norms. Lease deed for land cannot be considered. Column 3.
So how do you overcome that?
What?
How do you overcome this?
I am telling that under section 109, I become the owner once a irrevocable lease deed is there for 15 years. And the documents they want to verify in column 9.1, my lord, registered sale deed, mutation, gift, lease, 15 years agreement. And I have produced the lease deed.
Right. So this is the only defect, is it?
This is the only defect.
What does the single judge say?
Single judge says that the brochure says that you must own a land. And he has not considered 109, where the word own is specifically used. May I read it again? 109 of TP Act.
But the second problem that single judge is pointing out is the person who executed the lease deed for 15 years is not a member of the family.
Not necessary, my lord.
That is very much necessary.
It is not necessary. If he owns a land either by him or by the family members, then it is all right. But if he gets a lease deed executed, irrevocable lease deed by a person other than a family member for 40 years, then the ownership for that period will be with the person. So it will be he owns the property for that period. Yes, this is little bit ticklish.
Yes,
109, Lord, may I place it again?
All right.
If the lessor transfer the property leased
Yes.
or any part thereof, or any part of his interest therein, the transferee in the absence of a contract to the contrary shall possess all the rights, and if the lessee so elects, be subject to all the liabilities of the lessor as to the property or part transferred, so long as he is the owner of it. The specific word used in the statute is that he becomes the owner for that period.
No, he is the owner of it, is the lessor.
No.
Yes.
If the lessor transfers the property,
Yes.
or any part of his interest therein,
Yes.
the transferee in the absence of a contract to the contrary transferee shall possess all the rights, and if the lessee so elects, be subject to all the liabilities of the lessor as to the property or part transferred, so long he is the owner. This qualifies transferee.
All right.
Well, this is the only submission. And I may be permitted, now that the petitioner's counsel is not available to represent him, I was appearing in the writ also. Kindly permit me to.
Yes, Lord, your Lordship may kindly turn to page 50, which is the guideline for selection.
Right.
That I may draw your Lordship's attention to page 52, Milord. That's clause 4. Common eligibility criteria for all categories. Applicant applying RGGLV should be an Indian citizen. Milord, we are not concerned. Your Lordship may kindly turn to clause E and F. Milord, E has been dealt with by the Honorable Single Judge. What is a family unit? Milord, we are concerned with G, small g. Own a suitable land of minimum 20 meter into 24 meter in dimension at the advertised RGGLV location for construction of LPG cylinder storage godown. Own means, this is very important. We learned senior is interpreting something beyond the guidelines issued by the corporation for the selection of the distributor. Own means having clear ownership title of the property in the name of applicant, family member of the family unit, as defined in the multiple dealership distributorship norm. In case of ownership, co-ownership by family member, consent letter from the family member will be required. Land for construction, godown will be considered suitable. This is the criteria. My learned senior relies upon some other thing which is not germane to the issue. So what is a family unit? That has been defined in clause E of 4.
I'm not living as a member of the family unit.
I kept quiet when you requested. I expect the same kind of.
I only say that I am not claiming. I am claiming on my own.
No, that chart which he pointed out, which Mr. Mohanty pointed out, which had in the, this is 15 years lease. What is that document?
That's a verification report. Maybe the officers might have wrongly written it, but your Lordship, he is relying upon something which is not there in the brochure. Your Lordship is correct. I am answering that. Your Lordship may kindly turn to. That's a verification report. It's not a guideline. Please, Mr. Mohanty, I know you are anxious, but please let us go by, please.
73.
Yes, it begins from page 72. That is a field verification credential submitted by the officers. But the officers also cannot go beyond the brochure, the guidelines for appointment or selection of the LPG distributor. Something might have written here that doesn't qualify the clause. He doesn't satisfy the eligibility criteria. Okay. I don't think there is informity in the judgment of the Milord. That has been dealt with. E has been dealt with. Milord, I am showing another clause further. The G and E are to be read together. They are not, Milord, inseparable. So if it doesn't own a land, lease may be cancelled any moment, because the original right, your Lordship knows, in a leasehold property always lies with the lessor. It is not, Milord, that can be revoked. So it's a question of permanent setting up of an establishment at the cost of the oil company. So he can't rely upon some other document which is not germane to the material or the brochure and claim that in view of the provisions in the TP Act, I should claim the ownership. So therefore it should be settled.
All right. All right.
So this verification report, Millard 73, is by the field officer. So they can submit something, a report contrary to what Millard, they have also clearly found that he is not eligible. Millard 73 at the last column, verified with original, Millard serial number 9. Original documents verified as per application, applicant had declared ownership of land by registered sale deed. Documentation, mutation, Millard, she has declared that I am the owner, they own by self.
Yes.
Self, a record dated 16/12/2008 for Khata number so and so. On verification, it was found out that no registered sale deed, gift deed, mutation available with applicant, but the applicant had registered a lease deed number so and so, dated so and so, norms. Lease deed for land cannot be considered. It's clearly written by the officers verifying this.
All right.
Lord, may I just, Lord,
Yes.
The verification format, it is a format, my lord, quoted by the corporation, my lord.
Right.
And that was given in the counter, my lord.
Yes.
That is an annexure to the counter affidavit.
That's okay, but that's not part of the guidelines, sir.
Then, my lord, I am not claiming as a family unit, my lord. I am claiming under G, my lord. Own a suitable land, my lord. So, own means what, my lord? It is a irrevocable power of attorney, registered power of attorney for a period of 40 years. And it cannot be just revoked at any time at the sweet will of the lessor, because determination of the lease is a procedure to be followed, my lord, on the TPI. So, the question that my Mr. Acharya is submitting, that own has to be given a meaning as defined on the Transfer of Property Act.
All right.
May I just add one and for the respondent number 2, may I just one more aspect to what my learned senior Mr. Acharya has said. My lord, may I kindly turn to page 24.
Yes.
In fact, this is the application form of the appellant. In fact, your lordship would kindly turn to the next page 25. Against the column, do you own a specific advertised location for LPG godown or showroom? He has said no. Yes. Then down below, my lord, in the table, date of registration of sale deed, give date of mutation. He is giving a date. Now, there he has also not come out fairly that he is going with a lease deed of 40 years, whatever. So there he has said that I am the owner of the land, and the date of registration of the sale deed stroke gift stroke date of mutation is 1512. So the honorable single judge has also stated that there is a misrepresentation in the application form by the appellant.
What?
Blood, like column, there is no column for lease deed. That is why I have written the date.
All right. All right. You say the challenge in the present appeal is to an order dated, judgment dated 28 July 2014 of the learned single judge dismissing the appellant's writ petition civil 20066 of 2010. Paragraph. The appellant applied under the Rajiv Gandhi Gramin LPG Vitrak bracket liquefied petroleum gas oblique cooking gas bracket scheme for a distribution for a distributorship for Jhumpara in Kionjar district in the single courts open category. Full stop. Pursuant to the said application made on 30th December 2009, the appellant was asked to participate in the draw of lottery on 28th May 2010. Full stop. on 9th November 2010, while other applicants who had participated in the redraw of the lottery on 30th, were asked to participate in the redraw of lottery on 30th November 2010. The appellant was not given any such intimation. Full stop. Questioning the said decision, the writ petition was filed by the appellant. Paragraph. In the counter affidavit filed in the writ petition, it was pointed out by the Indian Oil Corporation Limited bracket respondent that among the reasons for the appellant not being selected was that she did not own the land which was offered for the distributorship. Full stop. Although in the application form, she claimed that she was the owner of the land and gave the date of her registered sale deed as 15th December 2009. On verification, it transpired that it was only a lease deed. And on the ground that in terms of the applicable guidelines, the applicant had to show ownership of land, the said candidacy of the appellant was not accepted. Paragraph. The learned single judge has upheld the decision of the IOCL, holding that the appellant had to have, single quotes, clear ownership title of the property in the name of the applicant or family member of the family unit as defined in the multiple dealership distributorship norm. Full stop, unquote. The learned single judge further found that by declaring that she was an owner of land in the application form, the appellant had misrepresented the fact. Accordingly, the writ petition was dismissed. This court has heard the submissions of Mr. Ashok Manthi, learned senior counsel for the appellant, and Mr. Pitabar Acharya, learned senior counsel appearing for the IOCL. Mr. Padi, whom are you appearing for? Oh. Oh.
Appearing for the persons called for redraw.
No, I am the successful one.
Is these success? These?
I see.
Yeah. Mr. Padi.
But were you implemented in the writ appeal?
Yes, my lord. By order dated 31 August 2016.
And Mr. S.S. Padi, learned counsel, appearing for the successful candidate. Paragraph. Mr. Manthi drew attention to the verification sheet prepared by the Office of the IOCL on scrutinizing the appellant's application, where the relevant remarks in the remarks column acknowledges that what the appellant had was a registered lease deed. So according to him, in terms of Section 109 of the Transfer of Property Act 1882, as long as there was a long-term lease, which in this case was 40 years, all the rights of the original owner would be available to the single quotes transferee, unquote. And therefore, it was as good as the appellant being the owner of the land in question. Paragraph. Mr. Acharya, on the other hand, refers to the applicable norms published by IOCL and which is applicable to the selection of distributors, which clearly required the applicant to be the owner of the land being offered for the distribution. Paragraph. There is merit in the contention of Mr. Acharya that the verification report was merely that and did not confer a right on the appellant to contend that short of ownership, even a land obtained under lease for a period of more than 15 years would satisfy that requirement. Specific clause in the published norms of the IOCL as set out in its brochure reads as under, reproduce the whole of clause G, page 53 bottom. Full stop. With there being no ambiguity about what the requirement was, comma, the appellant could not have possibly pressed for her candidature only on the basis of a registered lease deed, notwithstanding that the period of lease may have been more than 15 years for the land in question. Paragraph. Consequently, the court is unable to find any error in the impugned judgment of the learned single judge that calls for interference. The appeal is accordingly dismissed.
Right. The other item connected this WPC number 21568 of 2016. Where the challenge is to an advertisement for the self-some location.
Nobody's appearing in that. Nobody's appearing.
No, I am for the petitioner in that.
That was perhaps para 4 of the counter. We have said that that was inadvertently advertised. It was cancelled. I think so. He doesn't have any.
All right. In writ petition 21568 of 2016, in view of the statement in the counter affidavit.
At para 4 of the counter.
In para 4, that the advertisement was on account of a mistake, comma, no further directions need to be issued in the present writ petition and it is disposed of as such. All right.
Supplementary list passed over matter item number 32.
Please, Your Lordship. But this writ appeal involves these appealants who are in fact been lost their lands, agricultural as well as residential, owing to acquisition of their lands by MCL for expansion of mines. That's the only which Your Lordship will consider is that these appealants as well as the petitioners in the writ petition, they were promised to be resettled at a rehabilitation site. Now, the learned single judge was of the opinion and also disposed of the writ petition accordingly, that since they have been allotted with quarters as an interim arrangement, so therefore they are to vacate the lands in question for the operation of the mines. Now, my lord, still date, the interim management of the all these quarters is not done. The resettlement site, my lord, which was fixed in consultation with the villagers, that is not encroachment free. But under such circumstances, my lord, leaving the homestead, but that's the only homestead. They've already lost their agricultural lands. So the learned single judge, the only infirmity which I want to place before your lordship is that the learned single judge held that they have already been given employment and the interim management of their residence is also managed as an arranged. So therefore, they're not liable to hold on. But fact remains, neither there is an interim arrangement of homes, nor the resettlement site is free from encroachment, which I have also annexed. If your lordship kindly peruses my additional affidavit, which is at flag B.
Yes.
Which I have annexed the satellite pictures showing the encroachment, but that is the undisputed land which is selected for the resettlement. Page 80 of the affidavit, if your lordship kindly peruses.
So you have not actually been given plots, is it?
No, Lord, absolutely not. That's my case. No. There's no resettlement completion project as well, Madam.
Yes.
At that moment of time, one resettlement site, Gurjang, was done, which the villagers told we don't accept that. Then meetings were held with the district administration and the resettlement site was fixed, that is in front of South Baranda College. That was in Forest Division, so we had to take instructions. After getting all clearance, now we have already allotted plots to all of them. Out of the 102 petitioners, 31 petitioners have already started construction over their houses. Roads have been done, drains have been done, electricity has been provided. For water, tube wells and wells are there. So far as other water concerned, we given tender. So far as school is concerned, a plot is in earmark. Samshan plot is in earmark.
No, these 102, they've all been allotted.
Yes, Your Lordship. That's what I was stating in the morning.
You place it on affidavit.
Yes, that's what I was stating in the morning that I will place it in
Counsel for the MCL claims that all the 102 appellants have now been allotted plots in the resettlement colony and wants to place the details on record by means of an affidavit, which he states will be filed within 2 weeks with an advance copy to counsel for the appellant, who is permitted to file a response thereto for the next date. The other details of the development of the site of resettlement also be placed on record by way of the same affidavit. List on 18 January. Much obliged.
Pastor matter item 33.
May I please, Lords? The impugned order at annexure 20, by which the prayer of the petitioner for UGC scale has been rejected by Honorable Single Judge. But in the meantime, another judgment has been passed by Honorable Single Judge, and that is under challenge in Honorable Supreme Court in SLP number 354/2020, and this was the last week, and it was posted to 14th October. If it can be taken up after that.
All right. Counsel for the appellant states that the present appeal may be taken up after disposal of SLP civil number
3544 of
3544 of 2022. 2020. For liberties granted to the parties to mention for listing after disposal of the said SLP.
Obliged.
Adjourned Saturday. All right.
Item number 72.
I may be pardoned, Your Lordship. Your Lordship may kindly call up this after lunch. Senior counsel is appearing in this matter. He's on his legs in Bhubaneswar Court, Your Lordship.
Let's see what the matter is about.
Your Lordship, it's in challenging election single judge order rejecting amendment petition that has been allowed by the election.
How is a writ appeal maintainable?
Your Lordship, there are judgments to that effect, Your Lordship.
What?
Your Lordship, I do not have instruction to appear, Your Lordship. Senior counsel, Mr. Gautam Mukherjee, sir, is appearing.
I don't think a writ appeal is maintainable. Yeah, Order 6 Rule 17 was rejected, against which a writ petition is filed, against which a writ appeal is filed. I don't know.
Your Lordship, may kindly call at 2 o'clock, Your Lordship. He'll be back by then.
All right, 2 o'clock.
Obliged, Your Lordship.
Weekly. You don't call out, then nobody will appear.
Weekly list for hearing.
My Lord, item number 4 in weekly list. I may be permitted to place the matter on behalf of Senior Counsel Saktidhar Das.
Yes.
May I please, Your Lordship?
Yes.
Lordship, here the appellant has challenged the order judgment dated 27 June 2000, wherein the accused in the first petition is appellant Monokilo stands charged under section 302 IPC for having committed the murder of deceased Joya Andarba on dated 11/2/98 at 7 p.m. in village Kantigaon by stabbing him by means of a knife. The prosecution case in brief is that on 16/2/98, the brother of the deceased Joya Andarba, namely Madhav Andarba, appeared before the officer in charge of Padwa police station and lodged a report to the effect that on previous day, that is 11/2/98, the date of occurrence is 11/2/98, and the FIR was lodged on 16/2/98. His brother Mano Andarba was giving a daso 10th day feast for the death of his son, his cousin brother. The informant cousin brother was giving a dasa feast in his home, which was attended by all the villagers. After the feast, the persons who took active part in it were sitting near the fire at the kitchen place. At that time, the deceased came and sat there. The accused Monokhilo also came and sat there and pointedly asked toward the deceased that some person have drank his sarap, a kind of intoxication. Bleeding. The deceased could not say anything and breathed his last. When the incident took place, the informant reached this place on a hearsay by a village person. He moved there. He saw the body of the deceased, but he did not took any initiative make a postmortem, to make a medical examination. Rather, he took away directly the next day. He took away with the consent of the village person for cremation. So there is no medical examination report, no postmortem, no nothing in this regard. The prosecution threefolds. First is the informant who says that he, in his deposition, at page number PW, about a year ago, at page number 107, I know all the accused person standing in the dock. Deceased Joya Andarba was my elder brother. About a year and 6 months back, accused Mano Andarba was observing a dasa feast for the death of his son and invited all the villagers to attend the same. My elder brother, the deceased, was also invited and attended the same. All the accused person except the host Manu had been to the house of Manu Andarba to attend the feast. I arrived at the feast the evening after having my meal. I was sitting near the fire along with Dhanakilo and Buddhu Mudali. These have been examined. At that time, deceased Jaya came there and sat near Dhanakilo. He is also a subsequent accused, and he has been acquitted. Thereafter, accused Monokhilo came and sat near my deceased brother. At that time, accused Monokhilo declared that he had kept sarap juice for entertainment of his relative and that somebody has consumed the same. And if he could know who consumed it, he will kill him. My deceased brother then revealed that he has served the same to a guest. After that, an altercation ensued between them. Then I intervened in the matter and advised my deceased brother to leave the place. Accordingly, my brother left the place, but was immediately followed by the accused, Monokhilo. After some time, Buddhu Mudali informed me, PW7, informed me that something has happened to my deceased brother and I shall go to his house. Accordingly, I went to his house and found the deceased lying on the veranda with bleeding injury on his private part and right thigh. His two sons, Govardhan and Bhaskar, were crying at that place. At that time, my sister, Dangar Rani, arrived at the place. We examined the deceased and found we dead. Here in this case, on the date of occurrence, they did not took any initiative to take them to the medical to do the postmortem. They did not inform the police about the incident or wrote any complaint in the police station. Then Buddhu Mudali, then Buddhu Sisso and Ramakhila came to that place and declared that as somebody has committed the murder, police should be reported on the next day. But the informant did not take any step to do so. Manu Andarba, Gangadhar Andarba and Trinath Andarba, they are the appellant in the connected appeal. They have been charged under section 201, made accused. Then cleaned the blood stain from the ground. Manu and Trinath washed the dead body of the deceased. I wrapped a clean lungi on the dead body of the deceased. At that time, I opined that we should report the matter to the police. But Manu, Gangadhar and Trinath said that we should not report the matter to the police. And if I report the same, I shall also be killed. Not disclose this to anybody. As my grandfather and my sister were previously murdered, I became frightened and did not make any report before the police about this. His grandfather and sister were murdered, but the appellants are not involved in that. Myself, my sister Dangarani, Buddhu Sisa, Manu Andorba and Gangadhar Andorba stood guard to the dead body. Rather, the appellant in the connected appeal stood guard as to the dead body. On the next day, Buddhu Sisa advised that the matter should be reported to the police, to which the accused Manu, Gangadhar and Trinath protested. This has not been approved by the prosecution. As Manu, Trinath and Gangadhar first came out and carried the dead body towards the cremation ground. As these three accused person carried the dead body to the cremation ground, other accused person also followed them. Thereafter, my deceased brother was cremated. At para 5, the dead body was cremated on a Monday. On the following Sunday, accused Gangadhar host a feast by killing a goat. On this suspicion, seeing their merrymaking, I could suspect their complicity in the incident and decided to report the same to the police. Seeing this, the informant made a plan to have them in a conspiracy and reported a FIR against them. On the next day, I lodged a report before the OIC. That is on 16/2/1998. The occurrence took place in 11/2/1998. The sons of the deceased accompanied me to the Padwa police station for lodging the report. The OIC then reduced my oral report into writing. He then read over and explained the same to me. Thereafter, I signed the same. In cross-examination, it is stated that I lodged the report on Monday. Police came to our village that evening and also Tuesday and Wednesday. During the visit of police officer to our village, all the accused persons were present in the village. At first, the police took Buddhu Siso, Mangala Pangi, Hari Siso, Gangadhar Andorbo, Buddhu Muduli, and Bolu Siso to the police station. An election was scheduled, held on 2 days after the date of incident. At first, Manu Kilo was not taken by the police. The present appellant was not taken by the police as no prima facie case was against him. Then police then released all the above stated person as there was election. The person who were first taken by the police and subsequently released, they took accused Monokilo to the police station. Monokilo was then kept in the police station since that date. Para 6. Mandu Siso was also sitting with us beside the fire after the feast. About 30 minutes to 1 hour after my brother left for his house, Buddhu Midli came and informed me about the incident. When they were sitting before the fire and was an allegation of altercation between the parties, there were other persons also sitting, but they have never been examined in this case. The blood at Parade, 4th line, the blood-stained clothes which my deceased brother was wearing was removed by me. He himself has removed the dress. I had kept the same in a corner of the house, but somebody had taken it and destroyed it before the arrival of the police. He don't know who has taken it. He is only stating that somebody has taken. He himself has took out the dress and he has not taken any initiative to go for a medical postmortem. I could not find the blood-stained clothes of the deceased after the dead body was taken for cremation. The fresh lungi was not stained with blood. There are certain contradictions in para 9. We have landed property. My brother had sold some of his land. This is another story which is coming from the informant. On the Thursday, we have landed property. My brother had sold some his land. On the Thursday succeeding date of incident, a panchayat was convened in our village. In that panchayat, Gangadhar, Trinath and Manu Andorba insisted to cremate the dead body. And accordingly, it was decided by the panchayat to cremate. And there is no evidence that I was also present in that panchayat and I have insisted upon them to do so. They themselves decided in a panchayat and cremated without informing the police, without making any postmortem. It is not a fact that I had accompanied the cremation party to the cremation ground. It is not a fact that I did not state before IO that Buddhu Siso and Rama Kilo advised me to report the matter before the police because Jaya was murdered. It is also not a fact that I am frightened as previously my grandfather, my sister were. Again in para 8, it is there, in our village, females also attended cremation. Accused Ramokhilo also attended the same as all other villages went to the cremation ground. My wife also accompanied others to the cremation ground, but I did not go. There is a contradiction because the person who has been who is the solitary eyewitness, the PW1, he has stated in his evidence, I will come to that, he has stated in his evidence that the PW4 has lit fire to the cremation. And here in the cross-examination at para 11, he says, I did not go. There is another story of the PW1 who states to be an eyewitness to the occurrence. Rather, he has, by the learned court below, he has been stated as the solitary eyewitness. But he is an interested eyewitness. In his deposition, he has said he is the brother-in-law of the accused. That will follow. The deposition of PW1 at page number 99. I know all the accused persons standing in the dock.
No, but if he's a brother-in-law of the accused, who's working against the accused?
Brother-in-law of the deceased, my lord, I may be corrected. I may be corrected. I'm sorry. I may be corrected. He's the brother-in-law of the deceased. I know all the accused persons standing in the dock. I knew the deceased Jaya Andarba during his lifetime. I reside in a village, Tentuligura. He is not a village of the he is not the resident of the village where the occurrence took place. About 1 year, 6 months back, I had visited Kantigaon, the place of occurrence, the place of village of the accused. I had visited my daughter's house situated in the village. On the day the Dasa feast was being performed in the house of Manu Andarba, I went and attended the Dasa feast in the house. After taking part in the feast, I came back to my daughter's house and was sitting in the front of her house. At about 7 p.m., Shanvi. My lords, deposition of PW1.
It's not a delay of few hours, no? Delay of 5 days. Yes, please.
Yes, my lord. My lord, in page number 99. After taking part in the feast, I came back to my daughter's house and was sitting in front of her house. At about 7 p.m., I saw accused Monokhilo stabbing Jaya Andarba by means of a knife on his left thigh. The witness points out to the left lower abdomen just above the waistline. Monokhilo stabbed the deceased in front of the house of Mano Andarba. The spot is at the distance of 15 cubits from the place where I was sitting. That has been contradicted subsequently. And it was evening at that time, but I could not see the same as there was. I could see the same as there was some lantern burning. But as per the prosecution case, all the villages were present there, but none have been examined. None has come forward to give any evidence regarding the occurrence or incident which is being narrated by the informant. It was evening at the time, but I could see the same as there was some lantern burning. As a result of the stabbing, the deceased Jaya Andarba sustained bleeding injuries. After the assault, the deceased fell on the ground. Accused Manu Gangadhar Andarba, Trinath Andarba, then lifted him and carried him to the veranda of the deceased. Though I saw the incident, I did not raise any cry for help as I was frightened. I came back to my daughter's house and went to sleep. Seeing such an incident, rather to help him or to make any cry or to inform his brother, he did nothing. Straight away came back to his house, daughter's house, and slept. On the next morning, I learned that Jaya Andarba had died. I revealed before the village elders about my witnessing the incident, but none have stated that he has stated before any person about the occurrence, or none has been examined in that regard. On the next morning, all the villagers, including the accused person standing in the dock, took the dead body of the deceased and cremated it. After some days of the incident, the police came and asked me about the incident. I narrated the truth before him. He had never voluntarily visited the police station, never voluntarily given any statement before any person regarding the occurrence or the incident which he had seen. After some days of such examination by police, I was taken to the magistrate at Koraput, before whom I narrated the incident. That is after 1998, 2 months after the incident. Cross-examination at Para 4, very important. The village Kantigaon is situated at a long distance from our village. I had to take a train, get down at Palibhal, and then walk 1 hour to reach Kantigaon. Deceased and Madhava Andarba are brothers. Dongarani and Ichabati are two sisters. Their father's name is Soma. Ichabati is my wife. Here he says Ichabati is her wife, who's supposed to be the sister of the deceased. My daughter name is Sukri. She is married to Jagannath Khila of Kantigaon. The knife blow was given on the junction of the thigh and pelvic girdle. On the next day at about 12 noon, the deceased was taken to cremation ground for cremation. All the villagers, including the females, went to the cremation ground. Madhava Andarba and other charge-sheeted witness had also gone to the cremation ground. Madhava Andarba, the brother of the deceased, lit fire. Here is a contradiction where the informant says he has not been to the cremation ground, but he is the person who says that he lit the fire. It was decided by the village elders, very important, my lord. It was decided by the village elders to cremate the deceased, not by the accused person who have been implicated in 201 or the present appellant. Therefore, the dead body of the deceased was burnt in the cremation ground. Myself and Madhava also agreed. The informant as well as the present deponent also agreed to the proposal of cremating the ground, cremating the deceased without going to the police, without getting any medical examination. It is not a fact that at the time of the incident, I was sitting at the long distance and that I have not seen the incident due to the distance and darkness. But it was 7 of the evening in a village where lighting facility was very low. As he is saying, there was a lantern. So it is very difficult for him also because light was not proper. The house of Jaya Andarba situates near the spot of occurrence, but the house of Madhava situates at a distance. Madhav is the informant. I was examined by the police the day succeeding the date of report at village Kantigaon. I did not see any blood coming from the body of the deceased. Here he says that he has not seen any blood coming from the body of the deceased, where he says that he was stabbed by a knife in his lower abdomen. But by the time he was carried to his house, a column of blood found on the ground. I left the spot immediately after the assault as I was frightened. I did not reveal about the incident either to my daughter or to anybody else. Here he says he has not describe the incident to anybody, neither to her daughter where he on her house he slept. And before in the chief, he has said, I revealed before the villagers at para 2, at last line, I revealed before the village elders about the witnessing the incident. On the next morning, I saw the deceased Joya Andarba, who was lying on his front veranda. A lungi was wrapped on the dead body. There was no blood stain on the lungi. The lungi was wrapped by the informant. It is a fact that I have stated before the magistrate that I saw the incident from a distance of 20 to 25 cubit.
Yes, please.
My lord, at para 8, it is a fact that I have stated before the magistrate that I saw the incident from a distance of 20 to 25 cubits, wherein he has earlier stated 10 to 15 cubits. And I have stated to have seen the incident from a distance of 15 cubits. It is not a fact that I have not seen anything and that I am deposing falsehood as I am a relation of the deceased. The counsel for the appellant in learned court below also brought in that it is not a fact that I have not seen anything and I am deposing falsehood as I am a relation of the accused. Rather, he is a relation of the accused. My lord. And at para 10, I did not narrate the names of the person who took active part in the cremation of the dead body deceased before the magistrate at Koraput, nor did I reveal the names before the IO.
Also from the he's hardly served.
My lord, the defense has prosecution has examined as many as 14 witnesses.
We'll continue after lunch, sir. We'll continue after lunch.
This is 2011 Bombay, page 84, full bench. And your lordship may straightway come to page 20, page 100. Page 20, para 20 at page 99, your lordship. Firstly, see. Last few lines of that left-hand column. Sentence beginning, the writ of certiorari and under Article 226 of the Constitution, where the subordinate court or tribunal commits an error of jurisdiction, where the subordinate court or tribunal acts without jurisdiction or is in excess of it or fails to exercise jurisdiction, that error of jurisdiction can be corrected. Moreover, when a court or tribunal has acted illegally or improperly, such a breach of the principles of natural justice, the writ of certiorari is available under Article 226. Thereafter, next page, re 7. Where a petition is filed under Article 226 and 227 of the Constitution, as in this case, my lords, the facts justify the filing of such a petition is not lawful for the court to hold that jurisdictional error or errors resulting in a miscarriage of justice committed by the subordinate court or tribunals can be corrected only by exercise of powers under Article 227, and that mentioning Article 226 is redundant, thus depriving the party of a right of appeal under Clause 15 of the letters patent. Thereafter, 9. If a situation where a petition is filed under Article 227 of the Constitution and judgment is rendered in favor of the petitioner, recourse for appeal under Clause 15 of the letters patent is not barred to the respondent before the single judge merely on the ground that the petition was under Article 227. Now, there is a direct judgment of our own High Court, my lords, reported in 2019 1 OLR,
1037.
page 1037.
So there's a full bench of photos.
This
There's another full bench judgment. You've been shown that.
That is not. No, this is with regard to the election dispute. Paragraph.
Saying a writ appeal will lie, is it?
Yes.
Paragraph 6 and 7.
All right.
In applying the principle to the case.
All right. We just say on the issue of maintainability, Mr. Gautam Mukherjee, Learned Senior Counsel for the appellant, refers to the decision of the full bench of the Bombay High Court in Messrs. Advani Oerlikon Limited versus Machindra Govind Maksare, AR 2011, Bombay 84, and a judgment of the division bench of this court in Subhash Chandra Biswal versus Bamadev Patra, 2019 1 OLR 1037. Nevertheless, this will be one of the issues that this court will take up while hearing the petition. Notice additionally be served to counsel who appeared for the respondent before the learned single judge. What is the stage of the election dispute?
Issues are being raised. It's the stage of the issues.
We'll say notice returnable 18th October.
And stay of further proceedings because so that
Why stay? It will be because only issues, the stage of issues would.
In the miscase also notices may be issued. So that
All right. Notice in the IAOs. All right.
There's also a target, Manoj, to end the proceeding within 6 months. So anxiety is there. That
Yeah, let's see what happens on the 18th. All right. Yes, please.
May I please, Your Lordship?
Yes.
Your Lordship, now coming to the prosecution witness 14, who is the IO of the case. In the meantime, all the witnesses who are the Caesar witness, who are the photograph witness, and others have turned hostile.
Right.
The deposition is at page 124.
Right.
On 16/2/1998, 5 days after the occurrence, because the date of occurrence is 11/2.
Yes.
I was the OIC Padwa Police Station. On that day, one Madhav Andarba PW4 appeared before me at 6:10 a.m. and reported about the death of his brother Jaya Andarba, who was murdered by accused Monokhilo. As the information received by me revealed a cognizable case, I registered PS case number 12. After reducing his oral report into writing, reading and explaining the same to the informant at Exhibit 1 is the FIR. To the second. In the course of investigation, I examined the informant and the other person accompanying him, recorded their statement under section 161 CRPC. I visited the spot that night itself and prepared a spot and recorded their statement under section 161 CRPC. On the same night, I seized some blood-stained earth and sample earth from the inside the house of the deceased that is at 5 days later, wherein the informant himself has stated that somebody has burnt and everything has been disappeared. The connected appellants are convicted under section 201. On the following day, only I visited the spot again. Some more witnesses examined. I seized some burnt bones and numbers of burnt bones from the cremation grounds. To the next monokilo at 4:10 p.m. The time is important, my lord. While in custody, accused monokilo in presence of witness gave information Kantiga, where he brought out the weapon of offense, a knife, and produced before me. The knife was stained with blood. It is at a belated state on 28/2/1998. I seized the said knife and prepared seizure list. One Surender Kumar Jani took the photographs at the time of seizure, who has turned hostile and not supported the case of the prosecution. Exhibit 4 are the said photographs. I forwarded the accused to the court on 1/3/98 after 2 days. On 13/4/98, on my prayer, the learned SDGM Koraput forwarded the seized article to RFSL Barampur for chemical examination. Wired his office memo number 1362. Exhibit 8 is the office copy of the said forwarding letter. Exhibit 9 is the chemical examination report submitted in response to Exhibit 8. On 4/6/98, after 4 months, on my prayer, the JMFC Koraput recorded the 161 CRPC statement.
It must be 164. Yeah. It must be 164.
Typographical error.
Right.
PW1 Ramachandra Hantal, who is the solitary eyewitness, rather
Right.
an interested
Right.
witness.
Yes.
On 25/4/98, I arrested Manu Andarba, Gangadhar Andarba, and Trinath Andarba, the appellant in the connected appeal. On the next day, on 29/4/98, I arrested Mangala Mudli, such and such. I arrested accused Buddha Sisanath.
Yeah, you can skip all that. You can skip all that.
But to the last, the seized knife is not found in the court today. As material objection, MO, is not found in the court today.
Correct.
And this is also a very important point my lord may take into consideration.
Yes.
I have examined PW2 that has been turned hostile. At para 10, I have examined PW3. She has also turned hostile. At para 11, I have examined PW11. She has also turned hostile. At para 12, I have examined PW13. Mohan Kumar Panda, he is also a hostile witness. Now coming to the cross-examination. Para 13. Prior to 28/2/98, some persons whom I examined as witness implicated accused Manakhilo in the commission of the murder of the deceased. But later on, my subsequent investigation as material came to light against those persons, they have also been arraigned as accused. The accused person in the case. I arrested accused Manakhilo at Handipur Junction, which situates at the end of the village Kanti. The village Handiputs at a distance of 1 kilometer from village Kanti. At the time of arrest, I was accompanied by other police personnel and the photographer. None has supported, the photographer has not supported, nor any other police personnel have been examined. I recorded the statement of accused Manakhilo at 4 p.m. In the examination in chief, he has stated he has arrested the accused at 10 p.m. And now he's saying I arrested accused Manakhilo at 4 p.m. but have not mentioned the exact time. It is not a fact that I recorded the statement of accused Manakhilo prior to his arrest. There is a contradiction. As the accused was not able to write his own statement, he was able to sign his name only. I reduced his statement into writing. The accused has signed in Oriya. I have not mentioned anything in the case diary which revealed that the accused was not to write his own statement. Because it is relevant for section 27 discovery, they have created the same is not required. The bamboo bush from which the knife was recovered do not belong to any private person. there is no agricultural land or residential house near the bush, that the place situates at a distance of half kilometer from the village county. Earlier he stated 1 kilometer. Coming to paragraph 16. It is not a fact that the accused Monlok Kilo did not make any voluntary statement before me and led to the discovery of the bloodstained knife seized by me. On 34/98, I have examined PW1 Ramachandra Hantal at police station. 34. Examined. It is not a fact that I have examined PW1 Ramachandra Hantal on the earlier occasion. It is not a fact. I sent the statement of the witness recorded by me in this case along with charge sheet. It is not a fact that I did not send the statement to the court in due time and that I have created these statements to suit the needs of the case. At para 19, I have examined W4 Madhava Andorba, but I did not recorded his statement under section 164, it may be. But he has not examined him.
No, 161 only.
Separately, as he fully corroborated the FIR, he has stated before me that the accused Buddhu Siso advised him to report the matter before police, and that he has stated before me that the Manu Andorba, Gangadhar Andorba, and Trinath Andorba threatened to kill him if he make a report about the incident to the police. Now coming to the cross-examination. Madhava Andorba has mentioned in his FIR accused Manu, Gangadhar and Trinath insisted in the panchayat to cremate the dead body of the deceased, and the accused Manu and Trinath washed the dead body of the deceased. I have not recorded the 161 CRPC statement of the witness separately. There is no evidence to that effect. I have examined PW5 Gobardhan Andorba and recorded his statement under section 161 CRPC. He has not stated before me that accused Manu Andorba, Gangadhar Andorba and Trinath Andorba took the dead body of the deceased for cremation. So there are some more witnesses, but none of them have supported the case of prosecution. And now while concluding the case, I would say that the FIR has been lodged at a very belated stage, 5 days after, where the prosecution have all time to lodge the FIR, to do the medical examination, postmortem of the deceased, who is stated to be the brother of the informant, but they took no step in that regard. Secondly, there is no corroboration between the statement of PW1, who is the solitary eyewitness interested with the PW4, who is the informant of the case. Both have not supported the case of each other. There are contradictions between the chief examination and cross-examination of the statements made by the PW1 as well as PW4, wherein the PW4 states that he has not been to the cremation ground, and PW1 says he has lit the fire of the deceased. So the veracity is undoubtable. No villagers supported, in spite all the villagers were present in the Dasa feast that was done by the Dasa feast organized by Manu Andorba. As per the statement of all the PW1 and PW5, all the villagers were invited in the Dasa feast, but none has supported the case of the prosecution. PW1, who is the solitary eyewitness, he is the relative, he is the brother-in-law of the deceased. None of the Caesar witness supported the case. The photographer who was taking photograph during the 27 evidence leading to discovery, he has also not supported the case. So the whole story of the prosecution is based on surmises and conjectures. With this, I rest the case, my lord.
All right.
I have also given a citation and a small short date chart. My lord may refer to that.
Yes.
Regarding the evidence of the solitary eyewitness is there.
All right.
Yes, there is admittedly, Millards, one eyewitness who is not from this village, but he's related to the deceased. Why I say this is because the defense has raised an argument that it was dark. So since there is familiarity One doesn't have to see that whether it's dark or light at certain, and it's not a far off distance. But
what was the occasion for him to be there?
My lords,
he belongs to a different village.
He had come to his daughter's house, my lords. He had come to his daughter's house, and my lords, he's married to, my lords, the sister of the deceased. So, my lords, it's not like, and there was a feast there, so he had come, and it's not like he's planted. So
we don't know.
Please,
See,
my lords,
my lords, he keeps quiet for 5 days.
Please, my lords.
He simply says, I went off to sleep that night. And did not even tell my own daughter.
Definitely.
What is this kind of behavior?
Definitely, my lords.
He's related to the deceased. Please, how will he not tell his own daughter? I can understand if he's seen a stranger.
Yes, ma'am.
Then he should say nobody need not know these unpleasant things.
Yes, ma'am.
But your own relation has got killed.
Yes, ma'am.
How will he not say what after seeing your relation getting murdered? How will you not speak?
Millards, the way Millards different people react to
no relations.
Yes,
we're consistent with see we go on the road, we say one person hitting the other. We are not bothered about these things, we carry on with our lives.
Yes.
But if it's your own relation who's got murdered and you have witnessed the murder of your own relation, how will you not speak about it?
Yes, Millards, he's definitely not spoken, but the next day, Millards, he could muster courage and he narrated the incident to the villagers.
Next day.
Millards, to the villagers, Millards. Villagers and Millards.
Which villager?
Villagers, Millards, he hasn't.
That's the whole problem.
And Millards, no, Millards, in the cross also, he hasn't been questioned on that, or no suggestion has been put.
Why should they give a suggestion?
Yes,
if he has named a villager, they'll give a suggestion. If he has not named any villager, why would they give a suggestion?
Please, Millards. So that is Millards.
Not going to the police at all. You see, this man never goes to the police.
Never goes to the police.
It's the policeman who comes to him.
Millards.
And it so happened he came to him. We don't know how the policeman knew he had to come to him. That also we don't know.
If Millards, that is the case, Millards, when the police came to him, if he did not want to, if he wanted to conceal, or he wouldn't have said it. Why should
you conceal?
He wouldn't have said it to the police.
No. We want to know what is a natural behavior. If he had concealed, then he wouldn't be in witness at all.
Please, Millards. Please, Millards. So
testing is this a normal human conduct? Is what we're testing. How can this be a normal human conduct? Your own relation, you have an eyewitness to your own relation getting murdered.
That's right.
And you don't even tell the police this for 5 days, 6 days.
That's right, Millards. Well, definitely, Millards, the delay, Millards, is not sufficiently addressed.
Yeah.
Millards, I bow down to Millards' observation. The delay, Millards, is not sufficiently addressed, Millards. But Millards, the factum that he has seen it.
No, that is why this related witness having to test so carefully.
Yes, Millards.
So the caution is administered to court saying, not that you will not. In fact, in many of these murders, only related people will know.
Yes, Millards. Yes, Millards.
So they say don't discard related, but be very cautious in how you appreciate the evidence of related persons.
Please, Millards. Millards, from his evidence, even if we sift and see that he has seen that the murder has taken, so that is, Millards, not the factum that the murder has taken place. Thereafter, there has been a cremation, Millards. To that extent, Millards, there is nothing coming from.
See, look at that. He knows the evidence is disappearing, right?
Please,
if there's no postmortem, how will you know anybody got murdered? And he keeps quiet for that also.
Please, Millards. Millards, he hasn't, definitely, Millards, he hasn't gone to the police. Then, Millards.
He's allowed them to cremate. See, he's not even protested. Saying, how can you cover up the murder like this?
Millards, considering that he's not from this village.
And that is the point.
No, and
that's
Millards,
the point.
And Millards,
now he becomes a stranger.
No, Millards, and the elders of the village call whether to cremate or not, Millards, in reasonable, because that place is alien to him, except for he knows some of the people whom he's related to. Millards may
like he knows the brother. Like he knows PW4.
Yes, Millards.
Why would he not tell PW4? Ultimately, PW4 has a suspicion when there's a feast in the village. He says there's something amiss here, and therefore let me go to the police.
That's right.
Ultimately, the police is told by PW4, not even PW1.
Millards, and not by Millards PW1. That is right, Millards.
His consent has been taken.
Please,
He took a participant for cremation.
Yes.
He removed the apparels.
Yes, Millards. So, Millards, this is definitely means unusual behavior, but that wouldn't, Millards, be
There is no
fatal.
other witness. See, the point really is this.
Yes.
Everything hangs on this one witness.
Yes, Millards.
If he goes, there's nothing. There's no case for the prosecution.
Millards, but Millards, there are 3 post-occurrence witnesses. Millards, PW 5, 6, and 7. 5, Millards, is
all hostile.
Millards, 5 is not hostile. Millards, they have seen, Millards, these 3 accused and bringing the deceased to the veranda, and he was bleeding. My lords, I'll just take my lords to 5, 6, and 7.
That is the 201 people.
Yes, Millards,
not the
201
accused.
people. 201 people. So the fact that he was attacked and he
See, if 201 were finding an injured person on the road and brought him to the veranda, how can you accuse them of anything?
And Millards, this in conjunction
in fact,
with
if
PW4,
if they had been shown secretly taking away, in fact, this cremation happened right in the open village. Everybody participating.
Yes, this is Millards before when right after he was attacked, the 3 accused persons took him to the veranda where he was bleeding and where he took his last breath.
So what is unnatural? 3 villagers see an injured person, they bring him to the veranda of the house. What is unnatural in that?
No, Millards, when seen in conjunction with what PW4 says, that there was an altercation at the feast, then Millards, the deceased walks, the accused follows him. So Millards, that has to be seen put in context, Millards.
Correct.
As to the proximity in which Millards, the accused and the time, and then this person is found dead, Millards. So that, Millards, has to be seen because PW 5, 6, and 7's witness along with PW4, there is definitely, Millards, pointing fingers at Millards, the appellant here, Millards.
Only 4 talks of the altercation.
Yes, Millards. 4 talks of the altercation. 5, 6, and 7 see that he has come and he's at the veranda bleeding, and 5 sees that these 3 persons have brought him.
So vis-a-vis the main accused, he's the only one convicted for 302.
That's right, Millards.
What is the evidence other than PW1 and this PW4 saying they saw there was an altercation and this man went after
Millards,
that?
apart from Millards PW1's testimony, no one has seen except for PW4 seeing and heard that there has been an altercation and that is in person, and that he was followed by the accused was followed by the deceased. So, and thereafter, Millards, this has happened. So to that extent, Millards, PW4 has to be seen, and PW1, Millards, there's no material contradiction, so to say, from his cross. The fact that he has seen, that, Millards, is not shrouded in mystery, Millards. The fact that he has seen the murder, Millards.
No, we're now on murder, please.
Yes, Millards. The fact that he was being attacked by...
No, we can't convert this into circumstantial evidence.
No, Millards, I'm not. Millards, the fact
this is a case projected as a case of direct evidence.
Please,
so you have to test the eyewitness.
Please, Millards. Millards, the eyewitness, if I may read again, Millards, I'll repeat, Millards. Para 1, Millards, about 4 lines.
Yes.
After taking part in the feast, I came back to my daughter's house and was sitting in front of her house. At about 7 p.m., I saw accused Manu killer stabbing Jai Andraba by a knife on his left thigh. Bracket, the witness points to the left lower abdomen just above the waistline. Manu killer stabbed the deceased in front of the house of Mona Andraba. The spot is at a distance of 15 cubits from the place where I was sitting. So it is not very far. In the cross, he says 20, 25. That does not make it like way further from where he was. It was evening at that time, but I could see the same as there was some lanterns burning. As a result of the stabbing, the deceased Andhra sustained bleeding injuries. After the assault, the deceased fell on the ground. The 3 accused, he names the 3 accused. They lifted him and carried him to the veranda. This, Millards, is corroborated by PW5, who also says that these are the 3 people who got the deceased to the veranda. So there is, Millards, corroboration there, Millards, among the witnesses as well. Though I saw the incident, I did not raise any cry for help as I was frightened. So he has, Millards, expressed his mental state in as many words. I came back to my daughter's house and went to sleep. On the next morning, I learned that Jaya Andrava had died. I revealed before the village elders about my witnessing the incident. Now, Millards, I'll take Millards to the cross-examination, which deals with this, Millards, the fact that whether he has said or not, there is nothing coming from the cross, which Millards will find it at para 7 on the next page. I was examined by the police the day succeeding the date of report at village Kantigaon. I did not see any blood coming out from the body of the deceased, but by the time he was carried to his house, a column of blood was found on the ground. I left the spot immediately after the assault as I was frightened. So in the cross also, he maintains that he was frightened and he left. I did not reveal about the incident either to my daughter or to anybody else. Which, Millards, he's talking about that particular night that he did not, Millards. Thereafter, Millards, nothing is put to him that you haven't said anything to the village.
This is nothing for them to put.
Yes,
your
Millards.
Prosecution case. Why should they?
Please, Millards. Please. So for Millards,
they are not supposed to explain the gaps in your case.
Please, Millards. Please, Millards. So therefore, Millards, the fact that he has mentioned it to people the next day.
We don't know. Let's see what he says.
On the next morning, I saw the deceased Jaya Andrava, who was lying on the front veranda. A lungi was wrapped on the dead body. There was no blood stains on that lungi. So that is Millards it from his cross. So from this, Millards, my submission is that the eyewitness has seen the appellant assaulting the deceased falling, the three accused carrying the deceased to the veranda because the houses are not in front. And Millards, this is corroborated by PW5. Millards, I'll just take Millards to PW5. Govardhan Andar. I know all the, which is Miller page 112. Yes. I know all the accused persons standing in the dock. They reside in our village. Deceased Jaya Andarba was my father. The occurrence took place about 1 year, 6 months back. One evening, I was playing on our veranda. At that time, accused Manu Andarba, Gangadhar Andarba, and Trinath Andarba brought my father to our veranda and made him.
So I don't know. The charge against these three is about 201 destroying the evidence. How is this evidence helping? All this which you keep saying what PW1 said, PW5 according to corroborated. The fact that three accusers lifted him and brought him to the veranda, how does it make out 201?
No, Millards.
It's in fact contradictory.
Millards, what I'm saying is that...
No, the only charge against the three is not 302. It's only 201.
Yes, Millards.
How is this evidence which you repeatedly are referring to? How is it helping 201?
No, Millards, I am just saying that, Millards, PW1...
They are only on the guilt of...
Millards, that Millards, PW5, 6 or 7 has
nothing to do with all that, please.
Yes.
So I don't know why you're harping on this.
Yes. I was just showing that till what has the PW1 seen?
What we are only looking at the guilt of the main accused.
So apart from that, there is apart from PW1's evidence, there is nothing to show that he had assaulted. And this, when read with PW4's evidence, that deposition that there was an altercation which preceded this incident.
All right. And this IO seems to be so careless. The only thing he recovered is a knife, and that knife is also missing. And that knife isn't sent for chemical examination, nothing.
No, it has been sent. It has been sent, but it was the blood stains. It couldn't be ascertained because it was deteriorated.
And the knife also disappeared.
Yes, my lords.
In the trial, there's no knife.
The knife is. My lords may see the FSL report, which is at page 135. So it says knife.
No, but in
Yes, Millards. In the origin is human, but remarks is deteriorated and grouping no opinion.
Right.
So same with the blood-stained earth. So, but there's blood. So that Millards. That's about it.
All right. Anything else you want to say, Mr. Sattar?
My lord, where he is referring to the knife, there is no postmortem, no blood sample. It might be of anyone else, and he has kept in this case. There is no trace of that.
All right.
The PW5, who was at that time when the occurrence took place, he was 12 years and a half.
Right.
And when he deposed, he was 14 years, and he is supposed to be the son of the deceased. And there is no other trail in this regard. And only the interested witness is there, and no corroboration between PW1 and 5.
All right. All right. Orders reserved.
Right.
Obliged.
Item 6.
Item 6.
Item 6.
Item 6.
Millards, item 6, Millards, my friend can start. Millards, give me a base time. Millards, just.
All right.
Here the case, my lord, the entire conviction is based on hearsay evidence. Entire evidence is hearsay evidence, and the court has tried to create some circumstantial evidence, but not beyond reasonable doubt. What happened is the affair was lodged by the mother of the victim bride on the next day, stating therein that in 1995, my daughter was married to the accused number 3. We fulfill all the demand, such as cycle, ring, but we could not give golden chain. That is why there was a continuous demand from the side of the in-laws of bride that you give that chain, and they were not able to give that golden chain. On 29 January 1998, this alleged occurrence was alleged to be occurred, my lord. The case of the prosecution that the accused person killed the victim, thereafter cremated in haste, and when we got the information, it was evening. Nobody went to us to call us. The affair was scribed by PW10, who is the maternal uncle of informant, who is PW11. While the affair was lodged, it was lodged with the subject matter that the suspicious death of my daughter. And investigation was sought for. So far as lodging of affair, it creates a great doubt that on 30th, that is the next day, was lodged or not. The PW11 said in her deposition that she went to the police station on the next day evening to lodge the affair. That means on 29th daytime morning 10 a.m. This happened. In the same day evening, they got information. And the next day evening, on 30th evening, she went to the police station to lodge the affair orally. Nobody accompanied her. That is important. The police officer in their Fandi, it was outpost, he advised her to come with a written report. Immediately when she came out of the outpost, she met with PW10, who is the maternal uncle of PW11, the informant. PW10 scribed the affair, it was handed over, and thereafter the police case was registered. it was the story of PW 11 that she went in evening. What PW 10 says, he went to the police station on the next day morning. Nearby to police station, my lord, he said, I have not gone to police station, but I
So why don't we read, instead of orally explaining like this, you just start reading the witnesses, because again we will be reading everything.
In page 86, PW 11. On the next day evening, proceeding to Balipadar police station OP alone, I orally reported the matter. As per direction of police officer to bring a written affair, I came outside, and at that time, my uncle Gaurav reached there, and I requested him to write down a report for me. But he had not accompanied me to the outpost when I first went there to report the matter. My uncle Gaurav took the written affair and presented it to the police officer. At that time, I have not gone with him. So from the place of scribing affair, I returned back to the village alone. Thereafter, I have not met any police officer nor gone to police outpost. I cannot say to whom my written report has been addressed. It was anyway, that is important. PW 10 says in page 80.
Yes.
Para 4 middle portion. On that night, after return from village Dengapadar, I disclosed this occurrence to Dukhi in my house. On the next morning, this report was scribed near Balipadar police outpost. Thereafter, I have not gone Balipadar outpost on the date of lodging affair. Also, I had not accompanied Dukhi, including Balipadar police station. At 9 a.m. morning, in mother of victim, they have deposed that we heard from the villagers of the victim, in-laws of victim, that she was killed and cremated. This hearing was over on that date, 29th. After lodging of affair, there was no subsequent material collected by police or brought to the record, or nobody deposed that after lodging of affair, any evidence was brought to the prosecution case. In a parrot-like statement, everybody said, 2 through 3, 4 witnesses said, we had been to the village of victim. There we heard from the villagers that she was killed. Nobody says how she was killed. Even after getting that information, the police officer, there are 3 IOs. First, the SI of outpost took the investigation, charge of investigation. Subsequently, after 4 to 5 hours, the inspector took the charge. After some months, the inspector took the charge. But no IO has given any diligence to collect some material just to connect that she was killed. Of the weapon used in murder, the extrajudicial confession taken care of. Here, 3 IOs took the investigation, and nobody collected any material except the hearsay evidence that we heard from the villagers that she was killed. And the defense case is, my lord, that was a Thursday morning, and there was Lakshmi Puja in their village, Jagannath temple. So villagers put pressure on the accused person to cremate it as soon as possible so that they will be able to perform the temple. In the meantime, the brother of accused number 3 went to the parental house of the victim. He stated about the death of the victim. The dispute arose that the mother of the victim and this PW10 who scribed the affair, they demanded 70,000 of rupees in the name of the son of the victim. so that that one will not be neglected. He came from the house of the parental house of the victim. He stated everything to the family of accused, or his family. So it could not be resolved. Thereafter, it was cremated. But it stayed there for 4 to 5 hours. It was not in source of victim after the incident. The IO says the PW11, the informant, accompanied me to the said village. He remained there. The utensils seized from the house of accused was handed over to the informant. The PW 7, 9, 10, and 13. These 4 witnesses who said that we had the incident from the villagers. PW 7 is the cousin brother of the deceased. PW 9, one villager of informant. PW 10, uncle of informant, the scriber of the affair. PW 13 is a relation of deceased. But nobody stated as to from whom they heard the news. Police even did not want to know from what was the source of that news. And the cause and manner of the killing. Police did not disclose that the accused person were absconding. Police said, we had been to that village. We seized the articles. Articles means some utensils. Some ass was seized. As seizure of ass is not helpful because it is admitted case that cremation was done. So far as the act of killing is concerned, that is not to accept hearsay evidence. And so far as motive of offense is concerned, my lord, the affair clearly indicates just before 1 week of the alleged death of victim, the mother of victim, the informant, has paid 4,000 rupees to the husband of victim towards golden chain. So I thought whether 4,000 was sufficient. I was searching in Google. In the January 1998, 24 karat gold was 4,045 rupees. So if we calculate accordingly for 22 karat gold, it comes 3,707 rupees for 10 grams. So they have satisfied the demand. After satisfying the demand, what remains to kill? When they were not satisfying, there was no allegation. After satisfying, this allegation came. And one more thing, my lord. Just before some days, they came from Surat, where the husband of the victim was staying, and the victim was also staying with her son. Of course, that coming from Surat of victim is disputed by the prosecution, by the informant. They says no, victim was staying in the village. They came from Surat for the reason that the father-in-law of the victim had to undergo eye operation in Barampur. It is admitted. PW1 and 5 are seizure witness of us, not necessary. PW2 is a barber of marriage, not necessary, admitted fact. PW3 and 4 are seizure witnesses of some utensils from the house of accused. And they all say they have no idea of seizure. When they reached the spot, utensils were already there in the veranda of the accused persons. And one more thing, the PW10 deposed in his deposition that when the body was taken to the cremation ground in a pyre, blood drops were dropping from the body on the ground. PW10 is the scriber of the affair. Admittedly, he belongs to a political party. He has admitted in cross-examination. This fact he has not told to the police. Exclusively, he has stated in the court. And if at all a person is injured by means of any weapon, the blood drops cannot remain for hours together. It clots. Well, the statement deposed by the PW10 is hardly believable. I'm pointing out some discrepancies, my. Deposition of PW14, page 96. I'm sorry, page 98 or so. PW middle portion, PW7 did not state before in-laws that 1 month thereafter, the mother and other villagers assured the accused person to give a gold chain or money equivalent thereof. That a week thereafter, the mother of Josna borrowed 4,000 and gave it to the accused person as money equivalent of the gold chain. That the accused person demanded more money. That accused Shambhu assured her to bring Josna to her parents' house when the mother Josna did not necessary.
498A is proved. 304B is proved. These witnesses are more than enough for that.
My lord, if a killing is there, what I humbly submit, is it not the responsibility of the state, the police officer, to know the fact how she was killed?
Yes.
3 IOs are there. What I humbly submit, my lord, till the affair was lodged, this information that the victim was killed and cremated was heard from the villagers of the accused person. That hearing of this news was over by the date of lodging of the affair. After lodging of the affair, nothing is brought.
Did they test the cremation ground ashes and all that?
Ash was collected. It is admitted fact that it was cremated after 4 to 5 hours. In a village, after it is ordinarily in night, even a person.
According to you, was it a natural death? Let's
Natural death. What, my lord? She was suffering from diarrhea.
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 Okay.
The reason of convicting, my lord, the trial court has discussed why a newlywed bride will suddenly die without any hospitalization or something.
Correct.
On that suspicion only.
No, but what is there must be some explanation, right?
Explanation.
Here is a woman who's living in your house. She's living with the husband and in-laws. One fine morning, she's cremated. What is the explanation? How did she die?
Well, actually, there was no hospital admitted in the village. And in village area, how many people come to hospital in far away?
No, I'm on 106, sir. 106 Evidence Act. What is your explanation?
And it was
this is something exclusively in your knowledge. In your house, she's either your daughter-in-law or the wife of your son.
That suspicion arises, my lord.
We're not on that. You must have an explanation. That's the law. 106 Evidence Act requires you to explain, sir.
And on that ground, the accused person have been convicted. My lord, except that.
No, what is your argument for that? At least tell us what is your argument. How do you meet that?
We have examined PW 1 to 3. PW 3, my lord, is the brother of the accused number 3. Sorry, PW 2. He has stated that she was suffering from diarrhea. He had been to other village to call a doctor. When he came, she had already died. And at that time, it was a harvesting season. The accused person had been to the cultivation field.
Alibi.
And
how he proved alibi? If you're pleading alibi, how did he prove it? Then burden shifts to the accused. If the accused is plead. So defense witnesses, what do they say? You've examined defense witnesses.
Defense witnesses, my lord, one was a person who is a drummer, and he accompanied the procession to the cremation ground. PW3 is the drummer, my lord. Sorry. PW1 is the villager of the accused person, my lord. He has stated that after 15 days of marriage, accused Shambhu took Josna to Surat, where he was working. From the time of her marriage till Josna died, she might have been resided in her in-laws' house for about 6 months in total, as she was going and coming from Surat. But what your lordship is asking me, my lord, about the sufficient explanation, admittedly she was not hospitalized. So from that only, if a case of murder can be derived, it is also, lordship may see, there is nothing, there is no confession of accused, there is no extrajudicial
No,
confession.
lordship has specifically told you about 304B and 498A. So what is the special means of knowledge of the husband or kith and kin?
In fact, there's a shifting of burden of proof in 304B. Correct? 498A also shifts the burden. 304B also shifts the burden.
498 so far is concerned. The
These are all offenses of presumption, correct?
The demand was satisfied. There cannot be any mens rea. Just before 1 week, the demand was satisfied as per prosecution story.
So demands are endless.
And what
demands don't stop.
Lordship, another thing I will point to. This is a case I was going through. Most of the things have been made in sitting in police station.
That is a standard defense everywhere.
It has been brought in the deposition, my lord.
Yes.
The first IO had been to the village on the next day. Their seizure was made. After his leaving the village, the second the inspector of police station, the second IO reached there. He taken the charge of investigation. Thereafter, the first IO left the village. The second IO seized the articles. It is case of the first IO, the statement of first IO that I left that village at 4 p.m. The second IO says the articles were seized in the evening. And the seizure list was prepared by first IO, the PW number. Admittedly, she had left the village. And PW 14 says, I have no knowledge about that seizure. So it is a clear case that everything was done sitting in the Thana, my lord. After 3 to 4 days, they were arrested. There are every chance of anti-rating this report FR, my lord.
That we have already argued.
My lord.
All right. Anything else, sir?
Lord Badar, answer.
Tomorrow.
I'll take it.
Tomorrow. Yes. All right.
Grateful.
Tomorrow. It will be there in the list.
Simple. Yeah. Anyone waiting for a matter? Are you waiting for a case, sir?
No. I'm just watching.
Have you found out about that item 1 and all that? Yesterday the counsel was not here.
Mr. Katkia is not present today, so he would be doing.
No, the counsel for the yesterday he was saying that
Mr. Raiguru.
Raiguru. What do you call it, Raiguru?
They'll get back.
Just call him and ask him to tell him the court is waiting for him. He'll come back whenever he comes. You must keep all their phone numbers and keep calling them.